licence at Lake Hawea. Could everyone make sure their phones are turned off, please? And today we're hearing objections. As we requested yesterday, we have all your written submissions and written evidence. There's no need to read all that out, but if you could summarise that for us, it would be appreciated. Is there any media people here? Fine, there's one. And this is also being live streamed and recorded. So I'll call upon the Ministry of Health.
Sorry, I apologise, sir. I've just got two minor matters to clarify.
Of course.
I've got copies of the picture that I only gave to some yesterday, so if I can hand that up through the hearings advisors so that all parties have a copy. And to clarify one other point, sir, there were a number of questions of Mr. Hall yesterday about external advertising, and following the hearing I spoke with Mr. Christensen. We want to confirm there will be no external price or product advertising. There will just be the Super Liquor brand as is shown on those pictures. There won't be an A0 specials poster, there will be no posters. And that, Mr. Christensen understood he'd already reached that position with either the inspector, but it appears we may not have communicated that clearly, but that is the position. There will be no brand or pricing advertising, you'll just have the Super Liquor brand as it's shown on those pictures.
Okay.
Thank you, sir.
Thank you, Mr. Young. Doctor.
Tēnā koutou katoa.
You'll need to be either sworn or make an affirmation, Doctor.
Affirmation.
Do you solemnly, sincerely, and truthfully declare and affirm that the evidence you're about to give touching on the matter before this committee will be the truth, the whole truth, and nothing but the truth?
I do. Tēnā koutou, Michael Butchard, Medical Officer of Health. So if the committee pleases, I understand that our evidence is filed as read, taken as read. There'll be some matters I'll address now in my oral submission, and I'll also be calling our witness, Ms. Alana Smythe, later on. So firstly, I want to address just one point made yesterday by counsel for the applicant regarding national studies, doing nothing to assist you. So the case referred to was ALA PH 21-28. I just want to draw attention to the fact that the factual matrix of that case has several important differences to this hearing. So as noted by the council, for the applicant, it was an appeal of an LAP. It wasn't a single licence application. The focus was on licence, closing hours, not an off-licence application. The location was a large urban city centre with easy access to police and ED, including ED data. The type of evidence that ALA was focusing on and that was given on the day was focused primarily on acute harm and crime late at night in a city centre. It wasn't focusing on the often hidden harm from drinking from off-licence products. Further, given the nature of this type of evidence, acute harm and crime, there were several other witnesses and their evidence at ALA's disposal, including 4 senior police officers, an ED doctor. So the result of that appeal, it was actually upheld. So the on-licence opening hours were judged to be unreasonably late. That was in line with Professor Caswell's evidence. So they didn't rule against your evidence. However, compared to the police evidence, those 4 police officers who were witnessing the late night crime and the ED doctor witnessing the presentations, Arla judged that it did little to assist. Well, that's understandable because they had those other sources of evidence. So it doesn't follow from this that in all cases, national studies will do little to assist. It was for that particular appeal of that LAP in Wellington, focused on licence, closing hours. That wasn't the intent of the para 45 quoted of the Arla decision, that it would set a precedent for all hearings of all natures, at all levels, everywhere. Further to that, there is precedent, in fact, in High Court cases where judges have noted the use of national studies, and they've not mentioned in any way that it's been inappropriate. One example, Shady Lady lighting. So in the High Court decision by Judge Churchman, at para 53 of that judgment, Judge Churchman notes that the use of national study by Day and colleagues 2012 was used by the Medical Officer of Health. That was to do with close proximity of alcohol outlets as associated with increased serious violent crime in New Zealand. There was no mention that it was inappropriate to do so. So I think the Shady Lady is more relevant to this hearing than the Arla Wellington LAP hearing was. Because Shady Lady was a single off-licence application. It was in the High Court, so it supersedes an Arla judgment, and it's more recent. And finally, on that point, to disregard national evidence relating to subject matter that is often best demonstrated by national studies due to the nature of the health data sets and the statistical limitations regarding size of populations, especially when they're small, would go against the object of the Act, which defines alcohol harm broadly, including any death, disease, illness or injury, not just those illnesses and injury that are countable by direct observation. There's nothing about that in the Act. So some alcohol-related health outcomes are best examined through national data sets, especially chronic health conditions. Sometimes it's the only way to do so. So I'll now focus on 2 aspects of the purpose of the Act. Firstly, that it is for the benefit of the community as a whole. Now, the number of objections received for this application is the largest of any application in the Southern District. No other licence application has had a greater proportion of the community objecting. So when such a large proportion of the community think that the granting of a licence will not be of benefit, how will the purpose of the Act for the benefit of the community as a whole be satisfied by granting that licence? Now, yesterday we heard from counsel for the applicant Rosedale case law, and quote that likely to carry less weight in reference to pro forma objections. I'd just like to draw attention to the fact that likely to carry less weight is certainly not the same as no weight. just less weight than someone who appears and can be questioned. The second point relating to the purpose of the Act that I want to draw attention to is that the purpose of the Act is put in place so that the new system is reasonable. Now, a reasonable alcohol licensing system, it follows from that, requires reasonable licensing decisions to be made. That's the sum of its parts. And for reasonable alcohol licensing decisions to be made, an understanding and appreciation of the magnitude of harm caused by alcohol needs to be understood and appreciated. You have to weigh the benefits and the harms, and you have to know what those harms are. That would be reasonable. So we must always keep in the forefront of the decision-making process the magnitude of those harms. Unfortunately, in our society, the magnitude of alcohol harm is often not well understood, and it's often underestimated. I think in part that's because there's often a focus on the acute harm. I think often in these processes and decision-making and evidence presented, there is focus on the harm that we can see and count easily, less focus on the chronic harm that we have to use national studies to weigh and measure. That chronic harm probably outweighs the acute harm that we see, such as crime, violence, ED presentations, and I'll speak to some of that further. So as we all should know, alcohol causes more harm in New Zealand than any other drug. Alcohol contributes to the development of over 200 health conditions. It's one of the biggest risk factors for cancer, stroke, cardiovascular disease, assaults, falls, car accidents, drownings. Interpersonal violence. That's often something behind closed doors, not easily counted. Self-harm, transport injuries, unintentional injuries, alcoholic cardiomyopathy, atrial fibrillation. I won't list all 200. In 2018 alone, in New Zealand, alcohol caused an estimated 901 deaths. Cancers contributed the greatest number of these deaths at 376, followed by injuries at 296. Alcohol caused an estimated 1,250 cancers. 13% of those cancers were breast cancer and 12.6% of those cancers were colorectal cancers. Alcohol caused nearly 30,000 hospitalisations, nearly 50,000 disability-adjusted life years, and nearly 129,000 accident compensation corporation claims. Now that harm, that's every year. The study and analysis was done in 2018. There's work in my organisation to enable us to break that down at a district level. It's not plausible to break it down for a level of 2,000 population, but no community is immune to that. Every community contributes proportionally to that harm. So alcohol use is also a known proximal risk factor for suicide. It was identified in approximately 1/4 of suicides in New Zealand. And alcohol costs New Zealand an estimated $9.1 billion every year, and that's noted to be an underestimate. 4.8 billion of that is due to fetal alcohol spectrum disorder. So that's the harm inflicted on others not the drinker. So Hawea is not immune to these harms. The community will be contributing its share of deaths, cancers, hospitalisations and other costs. So given the sheer size of alcohol-related harm, it's a reasonable position for a local person to object to increasing availability of this drug in their community. So I'm not surprised over 530 objections were received. It's a reasonable response to that burden of harm. So I'll briefly draw attention to some of the points in the written submission, some of the further points. So I want to draw attention to paragraph 33. Firstly, I just want to update, there's actually a typo in here. It's partly our fault, but there was a typo in the original document that we pulled it from. So the age range 11 to 24 is actually 11 to 18, and almost all of them were under 18. So apologies for that. So local data demonstrates harmful drinking patterns of local youth. The Upper Clutha Youth Voice Survey of 2023 found that 67% of people surveyed aged between 11 and 18 had consumed alcohol, bearing in mind most of them are under 18. 33% of them reported binge drinking. There's actually a small typo, again, apologies. 31% of the total responders reported binge drinking at least monthly. And we know from Connor 2011, so that's referenced in our submissions on para 29, that each new off-licence increases the odds of binge drinking. So putting those two things together, we know we already have an issue with binge drinking in this location, and that increased off-licences increase the odds of binge drinking. Just referring to Lion Liquor, so according to that judgment, if there's an evidential foundation enabling a link to be drawn between a real risk, which we have, binge drinking, of alcohol-related harm, and the grant of a licence, which is likely to increase the risk of binge drinking, then that harm must be minimised. I actually think we're above an evidential foundation here. It's my view that it would likely lead to an increase in binge drinking based on those two premises. And of course, binge drinking is excessive and causes disease and death, so it speaks to the object of the Act. Para 35. This speaks to vulnerability of the community. We saw in 33 how binge drinking is an issue for youth, so it's no surprise that it's likely an issue for the adult population too in this area. Now granted, the health survey is talking about the Southern Health District. It's not a large enough survey to provide statistical significance when you delve into a small population of 2,000. But at least in our region, Southern District Health region, we have the highest rates of heavy episodic drinking. So next, paragraph 37, there was discussion yesterday about vulnerability of the population, focusing on the economic vulnerability. Granted, Hawea is not deprived compared to the New Zealand NZ Deprivation Index. However, economic vulnerability is only one aspect of vulnerability. It's not the whole picture. So we've already seen another vulnerability, high existing rates of binge drinking and heavy episodic drinking. So another aspect of vulnerability is access to services. We cover this in paragraph 41. So there's no GP in Hawea. According to the multiple deprivation, index of multiple deprivation, the Hawea area where the bottle store is proposed, Longview, it's in the most deprived decile in the country for access. It's actually in the most deprived 7th percentile. So the region is geographically isolated. Closest emergency departments are Dunstan an hour away and Lakes an hour 13 minutes away. And we refer to the New Zealand Government's Rural Health Strategy 2023. Given that Hawea is a rural population, according to the index of multiple deprivation, the New Zealand Government's Rural Health Strategy 2023, I'll just quote one paragraph from that. Rural communities may be less likely to access health services for alcohol-related conditions and experience higher rates of alcohol-related health loss and premature death. Relationships with alcohol also influence mental health outcomes and riskier behaviour. There is also a perception that drink driving laws are less likely to be enforced in rural areas. There's growing evidence that additional alcohol outlets in rural areas have a greater impact on violence in comparison to those in urban environments. These impacts on rural communities must be considered when implementing alcohol control measures. So given there's no GP in Hawea, I am a doctor, so I would say this, but a bottle store before a GP is not the right order. So bringing that all together, we have in para 43, we have a known youth binge drinking culture, likely heavy episodic drinking of the adult population, geographical isolation from health services. So increasing availability of alcohol, including high strength alcohol, is likely to increase alcohol harm, not minimise it. So moving to section 44. This is focusing on amenity and good order. So I submit the application is likely to minimise the amenity and good order of the locality, contrary to the requirements of the Sale and Supply of Alcohol Act. So it's up to the DLC to consider whether amenity and good order of the locality would likely be reduced, and part of that assessment is cleanliness. And I'd like to call my witness, if I may, Miss Alana Smythe.
Would you be available to answer questions?
Yes, and I'll continue on briefly after the witness, if I may. Thank you.
Do you solemnly, sincerely and truthfully declare and affirm that the evidence you're about to give touching on the matter before this committee will be the truth, the whole truth and nothing but the truth?
I do. Thank you, Mr. Chair. My name is Alana Smythe and I'm delegated to act on behalf of the Medical Officer of Health under Section 151 of the Sale and Supply of Alcohol Act 2012. As we've already heard, all of our evidence and briefs have been read, and mine was fairly brief in nature already, so the summary will be fairly quick. I made 2 site visits to assess the locality around 107 Longview Drive, Lake Hawea, and the broader Lake Hawea Township. The key observations that I made were that the area included family-oriented spaces such as a playground and a school bus route. I saw no evidence of drinking or alcohol-related litter at Peter Fraser Park or Scott's Beach. However, alcohol cans, bottles, vaping products and cigarette packets were observed along the roadside bordering the Longview subdivision, including broken glass in some places. The proposed site is close to where primary school children are dropped off by the school bus, some of which walked home unsupervised, which indicated to me a perception of safety in the community. My observations highlight the proximity of the proposed off-licence to areas that are frequented by children and families, and some existing signs of alcohol-related litter in the locality. And I am available to answer any questions to assist the committee.
Thank you.
Yeah, thanks. It's interesting you're looking at for the rubbish around Peter Fraser Park, noting that's close to an off-licence. There's none there, so but there's no off-licence out Cemetery Road. Can you explain why you're highlighting that?
I just thought it would be a fair assessment to visit other similar areas in the Hawea Township to the Longview Playground to see if there was any notable alcohol-related litter or evidence of drinking alcohol in those spaces.
Okay. Did you do the same thing in other super liquor stores that are existing? Check what the environment is like around those
I
to
visited
compare?
the Lismore Park, I believe it is, near the super liquor in Wanaka.
What was the outcome?
I didn't find it relevant to this application to include in my evidence, but I did take some photographs of bundles of alcohol-related litter in that park area.
Okay. And you mentioned the school bus stop and the safety of children. What's the connection there with the safety that you're alluding to? Noting that other super liquor stores is a child education centre right across the road. People walk past that. I'm just trying to understand. You're emphasising that children and parents walking from the bus stop, there's a safety issue. I'm just trying to understand what that safety issue is with a commercial area opposite and an off-licence on it.
Yeah, I wasn't trying to imply that there was a safety issue. I think I was just trying to emphasise that there's proximity to a school bus stop and that some of the children that I saw walked themselves home, which to me indicated that parents felt safe to allow their kids to do that, as it is presently.
Okay, thank you. That's good.
Doctor, would you have the same view if a 4 square was established in this area with an off-licence?
I think that to answer that question, in the same way that I've done for this application, I would give it careful thought over a number of days, rather than give a brief answer. There are some, obviously some differences and some similarities which would have to be taken into account and weighed. Some of the obvious similarities are that it is an off-licence, however the product range is different. So yeah, I would want to weigh that carefully before giving an answer.
Okay, and just with, I hear what you say about binge drinking, and you've got access to statistics. Would it not be unreasonable to assume that you'll still get binge drinkers and youths drinking with the existing liquor outlets in Lake Hawea?
Absolutely, I think that is one of the points that I'm making, that we have existing binge drinking now.
But the fact that there's another outlet, are you asserting that could lead to an increase in binge drinking and youngsters drinking?
I am, based on the Connor 2011 study, which did find that.
Yeah, okay, thank you.
Yeah, I had a question, but I think you wanted to talk.
I do have some small brief points just to highlight, and then happy to answer questions after that. I'll be brief. I just wanted to draw attention to the fact 56, that recent New Zealand research has demonstrated a correlation between close proximity to alcohol, off-licence, and increased incidence of crime. Also, the fact that this is a residential area, and I have visited it, and there are many homes in close proximity. Just briefly on systems, staff and training, 61, we are concerned about the single staff member. I know questions were raised from the DLC on this matter too yesterday. 62, how staff breaks are going to be covered, etc. And on suitability, 65, we were concerned that in the application no sensitive sites were identified, where clearly there are some. So applications do need to take this aspect, or pay more attention to this aspect. And just finally, 73 and 74 just outline what we would usually include in our assessment, but we're unable to fully. Thank you.
Thank you very much. Any questions?
Yeah, thanks, Doctor. Just following on from the question from the chair, it's really to do with the consistency, and everything you've said is and given evidence on submitted. The question is, did you submit on the off-licence for the supermarket at Hawea? Oppose it? Sort of what I'm getting to is, where do you draw the line?
So what I'd say for a start, I don't know when that application was, and I've not been, this portfolio I've had for maybe 3 or 4 years. We do make decisions on an individual basis, application by application. I meet regularly with my team, at least weekly, often have further discussions. In terms of consistency, there's actually, I don't believe that there is any requirement in the statutory or case law, because we're supposed to take each individual application on its own merits.
Yeah. The other point I was going to raise was, you've raised it at your para 76, to do with section 100 of the Act. Once again, it's, I've done many decisions and many applications where the premises hasn't been completed. It was subject to, under case law, the building code thing, and Ministry of Health hasn't opposed it. So why now are you suddenly opposing something which you don't oppose on other applications?
So,
For the same reason, you've given the reasons you can't assess it, you can't do that, but you can't on these others, but you haven't opposed them. So once again, it's back to consistency. Yeah.
I take your point. However, I think that for the relevance of this application, it's not actually relevant what has been done in the past on other applications in this particular case. We have to assess on the merits. Now, if, for example, during COVID, we did very little of anything because of other work requirements, there are many factors that we have to take into account, as do everyone in terms of resources, and we're not bound what we have done in a previous application by what we do in a current application.
Yeah, well, I had one last week though, and that's current, and there was no opposition to it. So I'm just trying to understand,
Yes.
and it comes into, once again, back to the previous one. Based on what you've presented here, you'd be almost opposing every application. And I understand you've got to treat them case by case, but it's just trying to understand, a bit better on what the overall MOH approach is to this type of application.
Well, we're careful not to have overarching policies that we apply liberally to every application. We have to assess each application on its own merits. If there was an application yesterday and we didn't oppose on something or didn't mention something, and we do mention today, we're not bound
Yeah, okay, that's good.
in any way being consistent.
Last question, which you raised about the medical centre. What can the Medical Health and Health New Zealand do to fix that? Because we'd love to have a medical centre out there. Is there any action going on there?
Unfortunately, you're speaking to the wrong part of health. So I'm in the National Public Health Service. That would be a different sort of service delivery. We can play a role in advocating. I have zero budget myself personally, but I can always raise that with people higher up.
Well, you've raised it with us, so it'd be great if you do advocate for it. I know we're getting away from the subject, but while you're at the table, it's good to get the word in.
Yes, understood.
Thank you.
Just a brief follow-up, really. You heard in evidence yesterday quite a long presentation by the applicant, and your question 65, 66 and 67 of your paper, I'm trying to get as to whether you have changed your mind or in any way modified your mind as to the suitability of the applicant.
Well, I think my role is to present factors that we think are pertinent for yourselves to consider. So I still think that it is relevant for the committee to consider why were no sensitive sites identified. So that's our point in 65. Because I believe that by any reasonable understanding of a sensitive site, a destination playground would be one. And I think a school bus stop just over the road is another.
But that would be that's the limit to your question of the suitability.
All the points in my written submission still stand. I'm just drawing attention to some of them.
Okay. Thank you.
Thank you. As you know, there's no right to cross-examine, but you'll be able to make further submissions later. Okay. That concludes the evidence, the MOH. Thank you very much.
Thank you.
Well presented. So I now call Dr. Gordon.
Thank you, sir. So I assume that you've read my opening submissions, sir. Is that correct?
Yes.
Yep. Okay. So just to summarise the format of those, they begin with statutory issues, in particular the requirements of an applicant to put their best foot forward in order to expect the DLC to favour the application over opposition, which is itself evidentially based, so that's important. The other important element relates to the community-orientated approach of the 2012 Act and the increasing movements, I think, to recognise the role of communities in alcohol licensing, which of course was brought in very much under the 2012 Act. So apart from that, my submission had a section on 100F, a section on suitability of the applicant, amenity and good order, and the purpose and object of the Act. And so that's the structure. And I just want to speak to a number of those elements, in particular taking into account the applicant's lawyer's opening some of the legal points that that he made, and a couple of things I think which will be quite useful for clarity. So so I only expect to speak for 15 to 20 minutes, which my friend, I noticed, 43 minutes, so I'm going to definitely beat that target. And yeah, I've just got a few points. So the first one is I want to talk about section 100F because it's a really big issue, I think, for this application. So just to remind you, sir, the section 100F reads that the application which is made must be accompanied by certificates by the territorial authority that the proposed use of the premises meets the requirements of the Resource Management Act and of the Building Code. Now, so I don't know if you're lawyers or not, but in legal statutory interpretation, must means must. That it could have said may, but it didn't. It says must. And so there's a statutory requirement at the base that says that the application must include that. And of course it didn't. It didn't include either element, either the resource management certificate, which came in, I believe, in about June or July, and the building code requirement, which on page, on paragraph 15 of my evidence, I quote what is required by that. So if the work is built to the consented plans and receives a code compliance certificate, it confirms the requirements. So you can't give a building code certificate off the plans. The plans is the starting point. I think what we've got in front of us is actually concept design. And you've got concept design, and you've got final design, then you've got build, and then you've got the inspections that lead to the building code certificate, the BCC. And so it is not possible for you to meet the requirements of section 100, not that you have to, but for the application to receive, to meet the requirements of section 100F. Now, what I want to talk about is the implications of that, sir, because if you were to issue the licence on that basis, then simply because Arlo has decided on several occasions that much more finished properties than this don't meet the requirements and have sent that back to the DLC. So this, I quote two cases. There's never, by the way, been a ruling on a bare paddock, which is what's there at the moment. So there's never been an attempt to give up to licence, and that would be the headline: alcohol licence granted to bare piece of land. Yep. So the reality is that the surety which Super Liquor are trying to get by applying early for this licence is not going to be achieved, because the reality is that I've already been instructed that should we lose this, that we will appeal, and on the basis of 100F and maybe other bases too. So the other possibility that you have, although it's never been done, if anything like this length of time, is to give a licence on the basis that that it won't be activated until the Section 100F certificates is completed, which I believe is a period of about 2 years, which is expected. Now, so that is an extraordinary period. As you know, under licensing regimes, licenses are given for a probationary year. So there's a 1 year, Mr. Young talked about it yesterday, and then for 3 years. What you're asking this community is to pause their concerns for 2 years and then not to have another say. And then presumably immediately after that, you would issue a licence and there would be the 1 year probationary period. And then, so 3 years on from today, there might be another chance for the community to have their say. And so to us, that is a completely unacceptable approach. And Ms. Riley has already instructed me that that also is not an acceptable approach. So, I just really needed to say that this is a huge hurdle for the committee. And in my view, we shouldn't be here. The law says it's the application that must have the building code certificates attached to it. There's no thing. Therefore, the application is null and void. Therefore, we shouldn't even be here. The inspector should never have sent it to the committee. They should have said, no, sorry, you don't meet the inspection criteria. So that's the first point I want to make, sir. And I think in some ways the most important point. I don't see a way through this at all. Similarly, there was quite a lot of talk yesterday about things like CPTED and design compliance and so on. But the reality is that there's nothing to base that on except drawings at the present time. And those arguments are very weak because they can't be backed up by actual reality. So I want to talk about community engagement. So Mr. Young argues that there is no obligation for Super Liquor to consult, drawing on the Rosedale decision. There's a public notification suffices. And at the same time, there's a very strong put down of the community objections that they're not quite real because they were done on a form, that they're not real people, that somehow they've been perhaps cheated into it. Now, as far as I know, sir, nobody has told the council or the DLC that they made a mistake or made an error in filling in a form which was an objection to this licence. As far as I know, there is no huge list of people who are saying, we really want this liquor store, let's do it. Nobody, there were no people, we've been told these people exist, but look, there's no people brought in evidence. And there has been some social media stuff, so there's always social media stuff. People say, I want my rights to have my liquor store and so on and so forth. That is not the arguments that you need to look at. Your focus is on the Section 105 principles, which is, alcohol is not any commodity, it's a particular commodity. So I think that that's really important. In terms of supporting the communities, I've been really interested in some of these arguments. So, and what I take Super Liquor to be saying, sir, because we hear a lot about the support which is offered to communities. I think it's great that you offer support, but to me, support is something that comes from a heart, not something which is laid on the table as a bargaining tool. And I've been really shocked by the extent to which this application has actually done that. So what I see it being is Super Liquor saying to the Hawea people, oh, well, if you give us a liquor store, we'll give you lots of sponsorship and things. I'm not judging Mr. Christensen's good heart, because I think he has got a good heart. But the way this is laid out is if you get a liquor store, then you get community support, and I find that very difficult to cope with, and Ms. Riley is particularly upset about that. So that's that point. So moving right on. very, very briefly, there have been three other cases which have received, in the history of time, I believe, that have received more objection than this. They're Muria, a liquor store by Murai, near Rotorua, 1,116 objections. They are Rotorua Central Bottle-O, a case which was held a couple of months ago. Not Bottle-O, sorry, a Rotorua Boutique, it was called, and that had 740 objections, I believe. Don't quote me on that, I might have got the numbers a bit wrong. There was a case a few years ago in Kandala, Wellington, where somebody wanted to open a liquor store in Kandala Village, one of the wealthiest areas in New Zealand, and that was 550, plus quite a few lawyers, I believe, involved in that case. And then there's this one. So the reality is that the community did collect a large number of objections, each one of them heartfelt, and each one of them with their own key arguments. Further, there has only been one case, and I may be wrong, I'm sure that my friend will correct me if I am. I believe there is only one case which has brought more objectors with evidence to the table in front of a DLC, because people are scared of coming to DLCs for, try not to make them so, but they are. I believe the number's 29 as of today. And that case was a case that my friend and I were also involved in Mapua, which in the end had 37 community objectors gave evidence to a super liquor application there about, I think it was 3 years ago, and that licence also was turned down. And to diminish and undermine the level of community involvement is to really do these people a disservice, sir. The reality is that the Hawea community has come out in opposition in very large numbers, and today you'll be hearing the range of the evidence and that they want to bring and the matters that they want to bring up. This is serious business for the committee, and you should be proud and privileged to have the second largest number of objectors ever, because all over the country, DLCs say to us, where are the numbers? Well, So I just wanted to make that point. Fourth point is, my friend quotes Ponder Holdings in relation to the threshold for objectors, and he says quite rightly that Ponder Holdings says, that objectors have to reach they have to jump a higher hurdle if they want to win a case against the cogent applicant's case when there is no agency objection. Well, I think the obvious thing here is that there's a very strong agency objection from the Medical Officer of Health, who have brought a team along today. That, in our view, that is very relevant evidence, and so Ponder just doesn't count in relation to that. The other thing about Ponder, it's quite an old decision, and there has been a shift since then to a more community-orientated approach, starting really with Vaudrey in 2016, and moving on to a range of other cases, including, of course, the 2023 Court of Appeal case in Woolworths. This was a case related to the LAP, but a number of dicta were discovered in Woolworths, which are relevant, and in particular there was an upholding and a strengthening of Section 3 of the Act, which is the purpose of the Act, and the purpose being in the interest of the community as a whole, to do a whole number of things, and it does include the reasonableness argument, which I think is really strong, and also the idea, sir, that DLCs, which has happened in several cases this year, that DLCs may take a precautionary approach. That is, they can decline a licence on the basis that it may, that there's evidence that it may increase alcohol-related harm to more than the minor extent. And the precautionary approach is why the medical officer of health's evidence is so important is that the research underpins the precautionary approach, as does the evidence of objectives. So it's those two things together which make that important. So trying to move on quite fast, sir. So one of Mr. Young's quite strong arguments that he makes around the birth care argument is that harm can't be eliminated, so the Act isn't prohibition, and therefore there's little you can do for harm except minimise it on by reasonably good practices. And I think that the language which is used in this is a shift from harm minimisation to reasonable practices. And I think, you hear Mr. Young talk a lot about reasonableness. I think reasonableness is an important concept, but reasonableness cannot substitute for alcohol-related harm. Okay? Harm is the issue. Harm is what you have to do. It's the main Section 105(1)(a). The object of the Act, which, including harm minimisation. The recent decision in the High Court, the Gardner decision, Mr. Young calls it the Whitman Way decision. It's actually the alcohol inspector against Sing 13. The Whitman Way decision is a very important decision. And it does, I think, three things which are really, really important. And the first one is it says, and this is quite important for this because I've read some of your previous decisions and I think you do fall into this error, and you're certainly not the only DLC to do so. It says that amenity and good order is not the same thing as alcohol-related harm. They cannot be conflated at all. Very, very good mind, Justice Gardner, because I think there has been a blurring of the boundaries between one and the other. Now, amenity and good order issues are evidential-based. So when Ms. Riley gives her evidence, she will be talking a lot about current amenity issues and her fears for future amenity issues, the risks that are associated with that. What is needed for that is some kind of a causal nexus, that is an evidential relationship between this actual location and the evidence for amenity and good order. But alcohol-related harm works on a different legal principle, and that is simply a principle of an assessment of risk. Okay, so the risk is that alcohol harm will increase. The second thing that Justice Gardner said is that we've got to remember how broad alcohol-related harm is, and Dr. Bouchard also discussed that in a number of ways, and I do quote, sir, at if we find it, at paragraph 30 of my opening exactly what she said. And she got this list, I'll go through it in a second if you like, but she got this list from the 2010 Law Commission report, which of course is still alive, even though it indeed formed the law, and so I think it's worth thinking about alcohol-related harm. So, criminal offences including homicides, assaults, sexual assaults, domestic violence, public disorder, diseases. We've heard about these. Alcohol poisoning and accidental injury due to intoxication, sometimes causing death. Secondary harms visited upon third parties as a result of others' excessive alcohol consumption. And so the evidence which has been given in research is that the victims of alcohol harm is a bigger group than the perpetrators, if you like, if you want to put it like that. That people harm others as much as or more than they hurt themselves. And so you can see that in terms, obviously, things like family violence and so on and so forth. Then harmful effects on, and this is stuff which is not in the Act, but it's in the, but it's now part of the new case law. Harmful effects on educational outcomes, workplace productivity, friendships, social life, home life, and the financial position of households. And finally, amenity issues, public nuisance, litter, glass, noise, damage and destruction of property, and the costs associated with rectifying those instances. And so the third contribution of this High Court decision, by which you are now bound, is very, very interesting. And she says, she defines what minimisation meant. And she said, minimisation is to the smallest extent possible. So it's not just a little bit of a reduction, it's actually to the smallest extent possible. And so you have to say, in relation to your consideration, when you get to the object of the Act, that will this store lead to the minimisation of harm, all of those harms, to the smallest extent possible. Moving right along, sir. I've lost my list. This one here. So, Mr. Young argues absolutely correctly that only site-specific evidence of real risk counts. And when you're talking about amenity and good order issues, he is correct. But of course, where there's bare land, then what you actually look, the risk is of course a future risk, and so it has to be seeing as this conflation of amenity issues and alcohol-related harm issues. The risk is alcohol-related harm issues. The amenity issues are what's there at the moment and what may or may not get worse. The binge drinking example given was a really good one. Will binge drinking increase if there's a new liquor store in Hawea? And the evidence from the research says yes, and so that's an amenity issue. Then it's also an alcohol-related harm issue. So I think that there's a bit of picking fruit, I think, to do in this this analysis. My second to last one is the argument that proliferation of liquor stores or of alcohol outlets is not a ground considered by the by user. And it's true that in isolation, proliferation is not a Section 105 principle, but it is a relative relevant factor under 105 1H, which is amenity and good order issues, and also 106 so of the Act. So you'll be considering that. So when the locality currently has no off licence and already experiences littering, public drinking and a night alcohol ban from 8 p.m. to 8 a.m. 365 days a year, and you understand that an alcohol ban is a limitation on human freedom to make things safer for everybody. So it's not, alcohol bans are not put on lightly, they mean something. And of course there's the Christmas alcohol ban too. So the committee is entitled to find that even one new alcohol outlet will increase, it will decrease the amenity and good order of the area to a great degree. And finally, no, I'm done. Thank you for listening.
Would you like to call your witness now, and we can leave questions until her evidence has been completed?
Sorry, could you repeat that?
Beg pardon?
So I said, sorry, could you repeat that, sir? I just wasn't able to hear you.
If you go ahead with your evidence,
Yeah.
okay, and we'll leave questions of till after that's concluded. Okay, thank you.
Thank you. Okay, it's fine.
You swear by Almighty God that the evidence you're about to give, touching on the matter before this committee, will be the truth, the whole truth, and nothing but the truth.
Thank you. Tēnā koutou katoa. My name is Lisa Riley. I live in Longview, about 200 meters from the proposed site. I'm speaking as both a parent and someone with lived experience of alcohol harm. I want to begin by talking about the strength of our community and how people have come together on this issue. More than 531 people objected to this license, nearly 1 in 3 adults in our town. That level of engagement is extraordinary, and to my knowledge, among the largest numbers ever lodged to a liquor application in New Zealand. Of those objectors, 456 people, about 86%, live in Lake Hawea or Hawea Flat. These are our immediate residents, parents, business owners, workers, and whānau, the people who will live with the consequences of this decision. The applicant's lawyer has suggested that our objections were templates and lacked authenticity. With respect, that is wrong. The community asked Communities Against Alcohol Harm, a national charity, to assist in the use of a digital platform to make it easier for people to understand the law and raise their objections. If these local voices are discounted, the committee risks doing what happened in the Singh case last year, where community evidence was set aside for procedural reasons and the decision was later overturned. Next, I'd like to focus on what the law actually means when it talks about minimizing harm. Under Section 4 of the Act, your duty is to minimize harm, not balance it against convenience or profit. That means reducing alcohol-related harm as far as reasonably possible. That doesn't mean banning alcohol. A license can meet that test when it's in a true commercial area, well away from schools, playgrounds, and homes, in a town with proper police and medical services, with appropriate density, and run by an operator with a strong compliance record. What we have here is the opposite: a large liquor outlet beside a school bus stop and playground, outside the alcohol ban area, in a town with no police station, no hospital, and already one of the highest outlet densities in the district. Approving this license would not minimize harm, it would amplify it. I also want to talk about what this store means in terms of visibility and for what our children will be seeing every day. The proposal includes 7 large super liquor signs, which are bright, repetitive, and impossible to miss. Research from the World Health Organization, the Health Promotion Agency, and the University of Otago all shows that exposure to alcohol marketing lowers the age of first drink and increases later consumption. Even if children don't understand the word liquor, they understand the word super. That pairing creates positive associations with alcohol. This kind of branding is not neutral, it's a form of conditioning, and placing it at the entrance to a family subdivision directly undermines the Act's goal of minimizing harm. I want to take a look at the bigger picture, the number of licenses and what that means for the harm. If this license is granted, Lake Hawea will have 10 licenses for a population of about 2,340 people, 1 for every 234 residents. That's 3 times the density of neighboring Albertown and more than double the national average. The applicant's lawyer said national research does nothing to assist in assessing local impact. With respect, that's wrong. The licensing authority has accepted national research many times where local data are limited because the way alcohol affects communities doesn't change by postcode. New Zealand-based studies by Professors Connor and Cameron show that every increase in alcohol and outlet density brings higher levels of violence, family harm, and hospital admissions. Those harms are predictable and measurable, and the evidence applies directly to small towns like ours. I want to speak briefly about the applicant's record. They describe themselves as well managed, yet their Super Liquor Remarkables Park store failed a controlled purchase operation and was suspended. My lawyer requested how many CPOs have been held since then. The answer provided was 0. That failure remains on record and raises real questions about reliability. Good systems on paper mean little if they don't work in practice, especially in a community with no local police presence. I also have real concerns about how the applicant represented this proposal visually. The renderings and mock-ups provided to the committee show the store in washed out, muted colors that bear little resemblance to the bold blue and red branding used across every other super liquor site. Unlike Queenstown or Wanaka, Lake Hawea has no police station, no hospital, no after-hours medical care, and no public transport. When serious harm occurs, people have to be airlifted to Dunedin or Invercargill. We simply don't have the infrastructure to absorb more alcohol-related incidents. That makes the duty to minimize harm even more important here. This isn't an abstract planning exercise. It's about real-world consequences for a small community. Compounding those risks is the rapid growth of short-term holiday rentals and Airbnb properties throughout Lake Hawea. These transient stays bring a steady turnover of visitors, often here to socialize and drink, without the same sense of accountability or connection as permanent residents. When a high-volume liquor outlet is placed in a neighborhood that already has a constant flow of short-term guests and no local policing, that risk to amenity and good order increases sharply through noise, litter, late-night disturbances, and traffic. The effect is cumulative. Residents who have chosen to make Hawea their home lose the quiet enjoyment of their streets, and parents lose confidence that their children can sleep safely at night. That is the very definition of a reduction in amenity and good order under Section 105. Just this past Monday, the applicant's Super Liquor Remarkables Park store in Queenstown was ram-raided at about 2:15 in the morning by offenders using a stolen vehicle. They stole around $900 worth of alcohol, and the car was later found submerged in the lake. This is not a hypothetical risk. It happened this week at another of the applicant's stores. If something like that occurred here, it would be in the middle of a residential neighborhood. Children in Longview would almost certainly be woken in the night by the crash, alarms, and sirens, and many would be frightened for weeks afterward. Kids deserve to feel safe going to bed, not lying awake wondering if someone might ram through their local store or their home to steal alcohol. In a community with no police station or immediate emergency response, the trauma from a single event like that would ripple through families. Under Section 105, this goes directly to the question of amenity, good order, and safety. A license that exposes children to that kind of foreseeable harm and risk cannot possibly be said to minimize harm. In the Singh case, the authority overturned a committee decision because community evidence was ignored and too much weight was given to the applicant's assurances. If this committee discounts the view of the 86% of objectors who live in Lake Hawea or Hawea Flat, it risks repeating that same mistake. A license is not an entitlement. The burden lies with the applicant to prove that granting it will minimize harm, not simply that it can operate within the rules. For me, this isn't theoretical. I grew up in an alcoholic home with intergenerational alcoholism affecting men on both sides of my family. I would like everyone in this room, when you go home tonight and walk through your own door, to pause for a moment and imagine what it would feel like to live with people who make you feel unsafe every day. Then imagine being a child in that environment with no power, no protection, and nowhere else to go. Growing up surrounded by alcohol abuse is a harrowing experience for any child or teenager, and you don't have to look further than our own police reports to see that those same patterns of harm are happening in this community. These harms may be invisible in statistics, but they are real and they are generational. My son deserves a different reality, a childhood where adults actually work towards minimizing that normalization and risk. This community has done everything asked of it under the law. We have gathered evidence, actively participated in the process, and shown what genuine local engagement looks like. The Act asks one clear question: would granting this license minimize harm? The evidence on density, suitability, location, and infrastructure says no. This is not about prohibition. It is about the law doing what Parliament intended, protecting families, children, and communities from predictable harm. Thank you.
Would you want to call Mr. Rewe, is it?
I'm not sure if he's, sorry, I'm not sure if he's here at this moment. I think he was thinking he would be speaking at 1. Apologies for that.
So any questions? Niall, John, and then we'll break for lunch.
Yeah, thanks, Linda. Yeah, good. It's a question that I've already heard you raise earlier, and it's really just to understand why there was no opposition put in by you or many of the other community to the off-licence at the recently done for the supermarket, which would have taken, based on your numbers, the number of outlets from 8 to 9 or 9 to 10, which is, based on your evidence, significant. And noting that the supermarket is not a supervised area. It's enables children to go in, buy things, be exposed, and that. So it's just really understanding why there hasn't been the past concern quite recently and the significant concern now.
Fresh Choice is a supermarket. Sorry, I was saying, pardon?
So I missed what that first word was.
Oh, I said Fresh Choice is a supermarket. Its core business is in groceries, with alcohol being a very small subset of that. It's not an alcohol destination. What's being proposed here is fundamentally different to that. This is a dedicated, high-volume alcohol retailer designed to draw customers in specifically for alcohol. It is going to be positioned right next to family homes, a playground, and a school bus stop. The intent and the impact are completely different, in my opinion.
Thank you.
So Mr. Rewe has arrived, so whether you want to continue the question of Ms. Riley and then go to his evidence, perhaps?
No, we'll go for Mr. Rewe. Would like to give his evidence if you could.
Would you like to swear on oath?
Sure. Yeah, sure, swear on the oath.
Sorry, I'll leave one there.
Do you swear by Almighty God that the evidence you're about to give, touching on the matter before this committee, will be the truth, the whole truth, and nothing but the truth?
I do.
So Mr. Rewe, the committee has read your evidence Would you like to make a summary of your key points or just answer questions?
Just a quick summary. So what doesn't, is not in there is probably that from 2016 until 2020, I was on behalf of whānau Ora, I was the navigator for this area. So dealt with many families from, whether it be Albert Town, Hawea, Hawea Flat, and there were Māori or Pacific Islander that had numerous complex multiple issues. We recognise it, whānau Ora recognises it as one of the fastest growing Māori populations in New Zealand, and with that comes the issues that we have nationwide around alcohol, violence, family violence, all that. And then along with that, with the need for, when we become addicted or desperate around alcohol, we then resort to petty crimes, big crimes. I wouldn't be surprised if the recent super liquor burglary in Queenstown wasn't committed by one of my own, the Māori community. So that's my worry, is that, and I'm certainly not against business and business growth and all that, but my concern is that into an area that's primarily designed as a home for low-income families through the Community Housing Trust, is you attract those sorts of people that will come into there. So it's about ensuring that you have areas that are managed for that type of business that comes in. It's certainly not an area that has an infrastructure that would support or manage alcoholism and violence that comes with it. Also, in 2008, I was part of the local police district curbing alcohol related violence team, and we saw that the growth of outlets in Queenstown and Lakes District did actually contribute towards an increase in alcohol related crime. So thank you.
Thank you very much. Any question, John?
Sorry, Aaron, did you just repeat that last bit again? I didn't quite get what you
Yeah, so in my time as a committee member of the Queenstown Lakes District's Council Curbing Alcohol Related Violence Committee, we saw with the increase in liquor outlets, liquor retail outlets, we saw the increase of alcohol related crime that was significant.
Yeah, okay. So, yeah, you mentioned you're not against businesses, but it's a matter of having the appropriate business. So they're noting this is a zoned local centre or commercial shopping centre. They're basically saying there shouldn't be any outlets, even in a zoned area that's for alcohol.
So my understanding is there are 5 alcohol retail outlets in the Hawea area already.
Yeah.
For the size of the community, I would believe, my view is that it's significant, given that when I was a whānau Ora navigator, two of the whānau that I did look after had significant alcohol related issues. One of them was sexual violence due to alcohol.
Okay, thank you.
Mr. Oiwi, you'd be aware, I think, that the industry is actually changing here. From what I understand, that the 2 of the outlets perhaps will be closing in the future. And this particular application here addresses one in a built-up area. We're talking about a commercial area, sorry.
Yeah, my understanding it's the only social housing area in New Zealand that's been has within its consent the ability to have a retail liquor outlet in it. I might stand corrected, but that's my understanding. And my view is that you're going to have a whole lot of, given that it's mainly or significantly a lot of social housing in that area, that it's the low income and vulnerable people that will be able or given the opportunity to settle there. And the last thing that those families need is a retail outlet next to them.
Right.
A retail liquor outlet next to them.
Do you see that reduction in the, I think the hotel, if the hotel leases, goes out of takeaway liquor? And I understand a store also is going to close potentially in the future, that this would reorganise the takeaway.
So when you consider that Matt started up the Super Value, and he is a retail outlet for alcohol, and regarding the other two outlets you've just mentioned, you don't know what will replace them. I don't know what will replace them, and I'm not sure if it's a given that will happen, but you still have a significant player in Super Fresh Choice in the area that, and you have other outlets that could potentially be in that area.
Thank you. Thanks.
Thank you, Chair. I just have a wee bit of clarification on you've used the term social housing. Now, I don't know what the definition of that is, but this is not a social housing area. It was done under this special housing area legislation. Yeah, so I just want to clarify what do you...
Sorry, that's what I mean, special housing area.
Social housing, to me, I thought there was a definite term for it. We don't actually provide social housing here in, publicly supported social housing.
Okay, yeah, so my understanding is it's part of the Community Housing Trust area. So
there are some, yeah, that's right,
Yep.
yeah, understood, yeah, okay, thank you.
Cool.
Thank you very much.
Thank you.
I'll take a break now for lunch. Is Mr. Miss, whatever it is, Lindsay Schofield available?
Yeah, she's here.
Oh, yeah. We'll start with you, if we may, now when we come back. Okay. Come back at 1:30. 1:30. That's it. We can be shorter.
This one,
No, just give us a
how many others?
Yeah. Yeah, we'll meet again at 1. Is that okay? I'll just check the others are here in the order we've got. Warren Chin. Right. Chris Horan.
Yes.
Sandra McCauley. Right, we're good enough to go on with. That's good. Okay, we'll see you back here at 1 o'clock.
Excuse me, sir, I did make a request that tea and coffee making facilities be available to us in the centre. Do you know if that's been achieved?
They're available at the back of the room, Liz.
Are they? Yes. Fantastic, thank you.
Okay, thank you. Good afternoon, everybody. We're a bit peremptory for the lunch break. The committee have got a few more questions for you, Doctor, and Lisa.
Yeah, thanks, Doctor. Mine was more of a technical clarification. You referred to your paragraph 33, and your words that you said were slightly different than what's written in at paragraph 30. Where's paragraph 32? It was to do with the harm minimisation definition. Just want to clarify, you said that being reduced to the smallest possible extent, and then written here, I know it's a technical thing, but it's got smallest possible degree. So I just want to understand which is the correct word. I can look up I haven't looked at the case law, but yeah. No, we can sort it out later. But
I think degree is the correct.
Okay. Oh, yeah.
It is the correct term. I've used extent as a synonym for that.
Yeah, that's right. Just wanted to clarify that, just make sure we're consistent there.
You made me think so. I wasn't quite sure which one, but I'm pretty sure it's degree.
Yeah,
in
okay.
the...
Well, that's what's written here, and you were saying
Thank you so
else.
much.
Yeah, that was all I had at the moment. Thanks.
Question for Ms. Riley, please. Am I to understand that there is not a place for another bottle store ever in Hawea?
No, absolutely not. That's absolutely not my position. I think that there are a number of conditions that would need to be met, and I'm just saying generally speaking, not in terms of, legally, for it to be manageable for our community. And a lot of that has to do with my comments that I made on the lack of infrastructure, the density issues, that sort of thing.
And location?
Yes, and location, yeah. Away from sensitive sites and from residential homes. Yeah.
Thank you.
Yep.
Sorry, and a follow on from that, not straying away from this application, but looking at the scene and what's happening in the district and out at Lake Hawea, what would your position be for, if say, you say the door's not closed on another licence, but what about in that same bit of commercial land, a cafe with a non-licence?
I think, again, that would have to be weighed up very carefully in terms of what exactly that was going to look like. I think the density issue still stands. And I think the fact that there's no other commercial development there currently, I think the order of how things go in is really going to matter to the community.
Yeah, I understand that. Sometimes it's hard to control a bit, the order of things. When you say the density, you do accept, based on the latest accommodation survey and projection of the spatial plan and the council, that the projected growth out there is going to be quite significant in numbers?
I think there is going to be growth, but the rate at which that is going to happen appears to be up to the wastewater system currently, because...
Yeah, well, you can see the work on the side of the road. That's
yeah.
happening now.
Yeah.
Yeah, okay, understood that. Yeah, it's all very well looking at a point in time now,
Yeah.
but in, shall I say 5 or 10 years, it'll be a different environment. Yeah.
Yes, and unfortunately, we're talking about now or a year from now.
I understand that, yeah. Thank you.
Thank you very much. Lindsay Schofield.
What's the difference?
Swear of someone Bible, affirmations as you just mentioned, affirmation that will tell the truth.
Oh, affirmation.
Do you solemnly, sincerely and truthfully declare and affirm that the evidence you're about to give touching on the matter before this committee will be the truth, the whole truth, and nothing but the truth?
I do.
Now, we have your written evidence, so if you'd like to address any points in that, we'd be grateful. Thank you.
Okay. Okay, so I will take it as read that you've read that I've lived
Yes.
in Hawea for over 20 years as a very active member of the community. I'm here representing a very united community of over 500 objectors. I'm no expert. I'm in fact extremely daunted by this process. I've never attended a hearing like this before. I have never felt so strongly before about anything that has faced our community as a very concerned resident and neighbour as to the damage that this super liquor could do to our community, which I have lived in and loved for over 20 years. Frankly, it feels like you've done everything in your power to make this as difficult as possible for our community. Moving it from Hawea, changing the times for us to speak, it gives me very little faith in this hearing, to be honest. And in fact, Mr. Cox has already been quoted in the media as saying that it was pretty much a done deal. But I'm not a NIMBY, I'm not a killjoy, and there are 3 other outlets where people can go and buy alcohol in Hawea. Everybody in this room knows the damage that alcohol does these days. We had some very clear evidence given by the Medical Officer of Health earlier today. The harm that it does to both our physical health, mental well-being, violence and harm. I'm opposed to the application for several reasons. Firstly, the accessibility in this new subdivision. The fact, as I've already mentioned, there are 3 other outlets. Its location on Cemetery Road, which hasn't been talked about too much today, but a main arterial road, which already has a number of speeding and dangerous drivers on it. You can see it by the burnout marks on the road. Throw alcohol into that, and you've got a pretty heady cocktail for disaster. The location and proximity to playgrounds, housing, cycle routes and bus routes we've talked about. But most importantly, the main objection is due to the harm that alcohol causes in our communities. 16% of adults drink hazardously. That is potentially up to 1 in 5 of our households in Hawea. With no GP and no medical service, that is a huge number. It is well documented that regulation and legislation are the best ways to effect change. Just look at when mandatory seatbelts were introduced and how that reduced deaths on the road. The same needs to happen with the supply and sale of alcohol. But the alcohol industry is big and powerful and lobbies to make its sale normal and acceptable. As I mentioned, I'm no expert. I'm sure that the applicant ticks a few of the boxes about meeting their requirements under the law, training their staff, not selling to minors, mystery shoppers, yay, giving money to the local community. But where are they going to be when a young man buys a 6-pack of Woodies, crashes his car and kills his mate? Where are they going to be when a husband has a bad day, picks up a bottle of whiskey on the way home and beats up his wife and kids? And where are they going to be when a young person buys enough vodka to go home and kill themselves? Our community does not have the resources to deal with this. There is no GP, no emergency unit. 60% of adults drink hazardously. That is a lot of people in our community and we cannot deal with it. I implore you to use the law, listen to the community and reject this application.
Yeah, thanks, Lindsay. Yeah, noting you feel so very strongly about it. Back to the question we asked Lisa then, would you say no to any more alcohol outlets out there, full stop?
No, I think, as Lisa said, it's a matter of timing and the order of things. You know, putting a liquor store before a GP, I think, is probably the best comment of the day.
Okay. You talked about people buying a 6-pack, going out and drinking and all those things there, but they can still do that and go and do it in other shops out there, so...
You're just making it easier. It's on that main road, which is, you know, where cars are already speeding up and down. So it just makes it easier that people can go in there and buy it.
So you're expecting people to go in there and buy it and, and drink it before they drive away?
Well, they can be adding to what they've already drunk beforehand. Who knows what they're going to be doing.
Okay. Yeah. Thank you.
Warren Chin.
Would you like to swear an oath or affirmation?
Affirmation, I think it's the non-Bible one.
Sorry.
Affirmation, is that the non-Bible one?
Yes.
That's
yeah.
me.
Do you solemnly, sincerely and truthfully declare and affirm that the evidence you're about to give touching on the matter before this committee will be the truth, the whole truth, and nothing but the truth?
I do. Tēnā koutou katoa. Good afternoon, panel. My name is Warren Chin. I've lived in Lake Hawea community since 2021, although I have a long association with the township as my parents moved here in 1999. I've seen a lot of change happen in Hawea, and some of it to the better and some of it to the negative. And I just want to address some 12 points that I'll take out of my evidence that you will have read, no doubt, which is quite lengthy, so I won't go there. The key thing is, of course, that I'm concerned about the accessible high percentage alcohol. Correction, I'll start again. I'm opposed to the liquor store on the Longview division, subdivision of Hawea. It's a desirable environment that we live in, and I believe that it will be compromised by the proposal. So in my opinion, Hawea Township and its residents will be at high future risk of being vulnerable to a range of negative effects from a large, apparently not drive-through, but covered liquor store in the neighbourhood. I'm concerned that accessible high percentage alcohol will increase the likelihood of people consuming alcohol to intoxication, causing harm to the community. I'm concerned about the potential harm to young families and children and the environment if the proposed liquor store were established. In my opinion, the location is inappropriate, it's close to a playground, and I'm of the view that Hawea community will be confronted with an increase of known alcohol-related risks. There would be serious costs to the Hawea community with a new large liquor store in the Longview subdivision. Hawea would be better served by having more useful shops and services than it would by a liquor store. For example, a medical centre and a police station would be useful as well. Hawea already has 3 bottle stores in approximately to 2,500 residents, and in my view that's sufficient. I'm also concerned that the drinking and driving incidents may increase in the Hawea district. And in my opinion, the proposal for a liquor store by an external franchise is a bit of an insult to the Hawea residents who had no prior knowledge of the proposal. And I'll just address some of those points. So in the case of being concerned about harm for young families, there's been a lot of discussion about that this morning. We're dealing with a sliding scale. Of course, having nothing there would be an ideal situation, or having a smaller bottle store like we discussed earlier with the Big Fresh there, or whatever it is, the supermarket. But it's a long-term habituation issue. So society habituates to negative effects to the extent that we become conditioned to something. And in the case of having children nearby, they habituate, as we talked earlier, to the bright colours and super liquor, and this is the place where you go to have a good time. I don't want my 8-year-old son to become conditioned to these sorts of influences in the community. They will, of course, as they travel around the countryside, but I feel that I don't want that in my community at this stage. Regarding Dr. Bouchard's comments earlier this morning about thresholds, we're already there at a threshold in terms of discussing the matter right here today. If we were selling bottle stores that sold 100% water, we wouldn't be here. There is something about alcohol that brings us here today. And of course, we all know what that is. It's the harm, the risk, the consequences. And nobody can clearly calculate the risk factor, which is probability times consequence in this situation. But I don't want to be around to wait and see what the outcome of those calculations are going to be. So, in my opinion, it's at your behest to explore this community's threshold, which I think we have well and truly met. This community doesn't want another bottle store of this magnitude in its community, especially one that's selling hard liquor and only liquor. The grocery shop is selling groceries as well, and alcohol content drinks up to about 14%, I believe. That'd be red wine and so forth. The whole situation seems to be stacked in favour of the applicants and of the culture of alcohol consumption. If you step back a little bit and look at New Zealand's sort of track record of alcohol consumption, I'll put this aside now and ad lib, it's strongly machismo. It's a male-oriented hobby, if you like, drinking alcohol in this country. And the applicants are largely male business people. It's a machismo culture, and the panel hearing today's issues is entirely male. And many of those people that are objecting to this, I don't know if you've done the gender ratio, are more likely to be women. There are more women that are frightened of the idea of having a bottle store in our midst. I'm frightened of it too. I've seen what alcohol does around the district. We have some young fellas who probably get on the terps and do wheel spins in the area. I didn't expect that in Hawea. I don't quite understand why it's happening, but I would wager that it's strongly correlated with alcohol consumption. I could go on, but I don't think I will, because the key idea here is not all the technicalities of risk and the technicalities of papers written and all the work done from the health department about alcohol. It's that we don't want this proposal in our environment. Let's make Hawea an example for other places that the people in it, 530 plus of us, simply don't want it to a ratio of 2,500. It's pretty high. That needs to be listened to and addressed. Thank you.
No, you've done a very substantial submission, thanks, Warren. You did highlight in one of your hot points there, and I think I understand what you're getting at. You just had one point there. There would be serious costs to the community, the Hawea community. I presume you're talking about the harm type costs.
Many costs.
Sorry?
Infrastructure costs, social costs. A lot of costs.
So if it's not a bottle store there and another commercial business goes in, what's the difference on the infrastructure?
Local infrastructure. Yobbos with a carload of terps driving into a road sign. There are correlations. All of this, all morning, has been about correlation, likelihood of things linked to other things. You can guarantee that there's a greater correlation of misbehaviour with alcohol than there is with a shop that sells water.
Yeah, and you haven't got, so most of the people in Hawea don't actually drink much at all at the moment? They don't want,
I don't know.
Do they drink socially?
Occasionally.
So it's not, you're saying that alcohol should be banned, it's just a matter of you don't want another alcohol.
It currently is banned, and the application liquor store is just outside the alcohol.
It's only be banned in public places, it's not banned in houses and stuff.
No, it's not banned in houses, of course not.
Yeah, but bans are things that's up to the community. If they want to extend the ban, that can be done in the future, if necessary. But,
Yep.
Yeah, okay. Yeah, I'm just trying to get a bit of balance there, because we do hear a lot about the harm, but there are a lot of people out there that do enjoy social drinking, and instead of having to drive to Wanaka to buy, I think for the weekend they can possibly, or down the road they can walk.
We've returned to this time and again this morning. It's a continuum from absolutely nothing to 100. Imagine a place with entirely bottle stores and nothing else. That would be ridiculous, we'd all agree. So where's the threshold?
That's
it's
what
your decision.
I totally agree.
And in this case, the threshold is leaning further towards fewer bottle stores than more.
So you think in 10 years' time that threshold will change?
I would hope not.
Okay. Thank you.
I'll still be there.
Sorry?
I'll still be there.
Oh, interesting. Okay, thank you.
No further questions. Thank you very much.
Thank you.
Sorry, Chris Moran.
Affirm. Do you solemnly, sincerely and truthfully declare and affirm that the evidence you're about to give touching on this matter before this community will be the truth, the whole truth and nothing but the truth?
I do.
Please proceed.
Okay.
Any comments you've got?
I've lived in Lake Hawea for almost 20 years too. Having worked as a residential institution with damaged adolescents for 9 years, I observed many of the kids had alcohol fetal alcohol syndrome. Now, some of those kids were from parents who were who were adolescents. And so we knows where that go to. And I just want to say that, you know, we all know about adolescents that they're hardly known for their wisdom. So given that Longview is a new subdivision, striving young families, and they're going to have many adolescents in a short term. In my view, it's insensitive and insulting for a commercial alcohol outlet to seek to impose itself on this community with a substance that is by any measure unhealthy. I also worked in 2 prisons and spent 7 years as a probation officer. Now, people here will know, I expect, that more than 70% of the violent offenders in our prisons were fueled by alcohol when they committed their offences, often against the mothers of their children, who were frequently exposed to the violence. I should add that I like a drink in moderation. I believe it has a place in society. But in Lake Hawea, we already have a pub and a supermarket and a shop where alcohol is sold. We don't need another one, especially in a community that is shortly to have a high rate of adolescence. Now, we know that families and communities are the heart of society. And yet, you know, this community has made it abundantly clear that we do not want this place in our community. And I can understand the panel bending over backwards for this applicant in a kind of democratic way. But the fact is, all this is not necessary. You know, we've made our point. And now we are expected to spend all this time, energy, and stress. So this is not democracy. It's a distortion of democracy. Thank you.
Yeah, okay. Thank you. No. We can do without the clapping, thank you. We are following a process ourselves under the Sale of Liquor Act.
I'm saying the process is wrong.
Well, that's your opinion, that's fine. Thank you. Any questions, gents? Sandra McCauley?
Escape. Getting comfortable.
On film, please.
Do you solemnly, sincerely and truthfully declare and affirm that the evidence you're about to give touching on the matter before this committee will be the truth, the whole truth and nothing but the truth?
I do. So, I'm Sandra McCauley, and I've taken it that you've had the evidence that I submitted before you.
Yes, we have.
Which outlines a lot of my experience as a statutory social worker, both in this area and other areas in this. It outlines some of my experiences as a statutory social worker, both in this area and other areas in the South Island, and a social worker for the Youth Drug Court in Christchurch. So I'd like to just expand on my evidence a bit. The applicant has stated that Hawea is a stable, mature, well-functioning community and therefore not vulnerable to alcohol-related harm. But the proposed outlet is not being placed in the established part of Hawea, it is being placed in Longview, which is a new, rapidly developing, high-density housing area. The sizes of the sections are about half of the size of other sections in Hawea,
It is still in the process of forming its identity and community networks. Longview did not exist at the time of the 2023 census. There was not one person living there. It lacks essential infrastructure, including reliable wastewater systems and public transport. These are not characteristics of a stable or mature community. These are characteristics of a new and vulnerable one. Longview sits outside the Hawea township boundary and is bordered by a high-speed road. And as many residents know, Hawea and Longview are already sometimes viewed as less resourced or poor cousins compared to Wanaka. Placing a large, high-visibility drive-in liquor store at the entrance to Longview risks defining the community by alcohol availability before the community has even had the chance to define itself by connection, identity and belonging. The research shows that in new housing developments benefit most when early investment is made in shared spaces, support networks and opportunities for community connection. Alcohol outlets do not create social cohesion, they fragment it. By contrast, the applicant presents no evidence that placing a large drive-in alcohol outlet in a newly forming community benefits community well-being. The applicant believes that young families and working people struggling to get into home ownership are not vulnerable. However, it is widely understood, including in the Ministry of Health, MSD and local council wellbeing frameworks, that these are precisely the groups who may experience high levels of financial pressure, limited family support, childcare and work-life stress, greater transport and access barriers. These pressures make communities more vulnerable to harm from alcohol use, not less. And we know alcohol is often used as a coping mechanism when stress builds, for parents, for workers, and for families who are just trying to manage. Alcohol is a legal drug, but one that is heavily associated with harm when convenience and availability increase. The applicant's position does not acknowledge this reality. The applicant argues that it is reasonable for residents to travel 16 kilometres into Wanaka for medical services. He considers it unreasonable for residents to travel the same distance for alcohol at their nearest liquor outlet in Wanaka. So there are already multiple alcohol liquor outlets serving this area. There are 3 within Hawea, that's 2 to 3 kilometres, 1 in Albertown, 11 kilometres, and numerous outlets in Wanaka, including the applicant's own at 16 kilometres. This inconsistency suggests that convenience of alcohol access is being prioritised over community wellbeing. This community is not underserved. And I want to just say that no amount of staff training will stop young people accessing alcohol. They will get an older person to buy it for them, as they always have done. Their parents will give them alcohol for parties, etc. It is so accepted as part of day-to-day life. Or they may ram raid a bottle store. And I suspect that any liquor outlet in Longview at this point in time would be quite vulnerable to that type of crime. And there are no police and no ambulances in Hawea. So in conclusion, I wish to have it placed on record that if this drive-in super liquor outlet is established at Longview, it will shape how the community is seen, how it develops, and how safe and supported families feel living there. The risk is long-term. Once this outlet is operating, the community cannot easily undo its effects. So I want to be very clear, Longview and Hawea are still forming their social foundations, and these foundations are vulnerable. Introducing a large, high-visibility alcohol outlet at this early stage would create long-lasting social impacts that would be felt across Hawea for years to come. And it's for these reasons I oppose the granting of this licence. Thank you.
Thank you very much, Mr. McCauley. Any questions?
Yes, thank you. You made the note, which is pretty relevant, that back at the census 2023, there wasn't much out there.
There's nothing.
Right.
I was working for
Yeah.
the census at that time.
But 2 years later, we've got a lot.
It's
And
building
then,
rapidly.
so the way the growth is going in 2 years, what you've seen in 2 years, what do you expect to see in another 2 years?
Well, who knows, but we want social cohesion now at this early stage.
So based on your experience, have you ever been involved in a community like this, where a new community developing like this, say in Christchurch or somewhere else?
I've seen a few, like in Tauranga, Papamoa,
Okay.
and in the North Shore in Auckland. I grew up there. I've seen them when they were bare paddocks.
Okay, and how long did it take them to become a stable community?
I wasn't working in community development.
Sorry?
I wasn't working in community development then.
Oh, sorry, I was trying to get, that's what I was asking you from your experience.
I mean, it depends on the
Yeah, I-
community, doesn't it?
Yeah, it
It's
does.
in the hands of the community.
Just I'm trying to get it in perspective, you know, there's, you were giving evidence that it's not a stable community, based on your experience in other areas, and I'm just trying to understand when you see it becoming a stable community.
It's in the hands of the community, and I guess that's what I'm saying, that the community needs that opportunity to develop a solid foundation before things like alcohol is introduced.
Okay, and that's what you've seen in other areas? No alcohol outlets in communities we're developing?
There are dry areas around the country.
Whereabouts?
There's some in Auckland still, I think, and there are licensing trusts around the country.
Okay. Yeah. I'm just trying to get, do you accept though, then, when this community becomes stable, an alcohol outlet like this would be okay?
It's down to the community.
Sorry?
I think that's down to the community.
Okay.
The community needs to develop its sense of identity and what it wants to be.
Okay, understood. Thank you.
No, just thank you for a great
Yeah,
submission.
very, very well presented. Thank you. So next is Sandra McCauley.
That was her. That was her.
Erica Allen.
Yeah, that's me.
Oh,
Erica, I beg your pardon.
Would you like to swear on oath or affirmations? Affirmation.
Do you solemnly, sincerely and truthfully declare and affirm that the evidence you're about to give, touching on the matter before this community, will be the truth, the whole truth and nothing but the truth?
I do. Good afternoon. My name's Erica Allen and I've owned a property in Lake Hawea for over 30 years and have been a full-time resident for about 3 years. I care deeply for the future of the Hawea community and I'm actively involved in the Hawea community through activities with the local community centre and my involvement with the Hawea Community Association. I know you have my submission, which I presume you've read, with respect to the liquor licence and the proposed super liquor on the corner of Longview and Burton Loop, so I'm not going to repeat that content. The changes in the Hawea area do not suit everyone, but as a community, we want to do whatever we can to support the people that live there and who will live there in the future. My submission, or much of it, was based on my experience as a volunteer for the local trust Food for Love. I don't know if you know much about that, but we look after a lot of people across this region. This involvement takes me into local homes on a weekly basis as I provide meals and social support for families who need help. Many of these are based in Longview. In fact, the large proportion that I do every week is in Longview. It takes me into people's homes. The help is required because of illness, bereavement, loneliness and isolation. These families are vulnerable. Generally they're young and are isolated from the support of family and friends because they are often new to the region, with many coming from other countries or regions of New Zealand. We'd call them displaced citizens in a way. They've come from somewhere to somewhere else without family, friends and networks that are starting all over again, and there's lots and lots of them. Many are struggling to survive on a day-to-day basis, and that's why we're feeding and caring for them. In these homes, I see a lot of signs of alcohol consumption when I visit them, and generally it's between 4 and 5 in the afternoon. So they've picked up the children from school, they're at home, they're having a glass of wine, I have a chat to them when I drop off their meals.
My example in my brief of evidence tells the story of a young single mother with 3 children, who when I said to her, and I didn't lead her into this, I said, what do you think about a liquor store along the road? She said to me, I don't want it. I don't want it so close. And the reason was she knows that she will up her normal intake of 1 bottle of wine a day to more, because she'll just have to walk along the road and buy another one. I left that house in tears. I went, this can't be right, because I have never been in that sort of situation before. But it really brought it home to me that we have very vulnerable people there. I recognise that with population increases comes the need for extended commercial activity. I don't doubt it. But this needs to be carefully planned to best reflect the immediate needs of a growing and changing demographic. In the future, there will be a commercial centre in Longview that includes a range of outlets: food, medical, pharmacy, convenience, and much more. A liquor store may be part of that, but my question is, does a standalone liquor store send the message that having another off-licence liquor store in a village of Hawea that already has 3 outlets is the most important starting point? We've already seen evidence of drinking in public spaces with the bottles and cans scattered along the roadsides in Longview and Cemetery Road. The recent Community Clean-up Day illustrated this. And another part of that is that there's nowhere for young people to go in Hawea at the moment. So they don't have a hub, a community area. There's kind of nowhere. So they roam around on their push bikes or whatever, doing all sorts of crazy acts. Most of the time they're good-natured, but there is a definite lack of community support for young people, and it's something we need to address. Incidents of burnouts on local roads and reserves plus vandalism is definitely increasing. There's a risk that increased access to alcohol will also lead to increased harm in the community. Yes, people have to be personally responsible, but as a community, I believe we also have to assist with and facilitate positive developments so that individuals can make good choices. We need to prevent alcohol harm because we know that alcohol is a highly addictive and harmful drug, there's no doubt. Normalising alcohol consumption and making it more readily available does not prevent alcohol harm. As many have already said, Hawea doesn't have a medical centre or a hospital, there's no police station, and we're forced to wait for support or rely on our local volunteer fire brigade because they're the only people we've actually got on the ground to help when harm comes our way, and it comes regularly, believe me. My hope is that you will understand that Longview and Hawea does not need another off-licence liquor outlet at this point in time. Thank you.
Thanks, sir. You mentioned the term standalone liquor store. Do you mean having a liquor store there on its own, or?
Yeah, I do. I just mean front, centre,
okay.
Most important thing.
You accept that that commercial area is likely to be full of commercial development over the next couple of years?
Absolutely, in the future.
So it won't be standalone?
Absolutely, but at the moment it is, and so to me, first, front and centre sets this is the most important thing our community needs right now, and I don't think it is.
Okay, well we can't predict the future, but it won't be built tomorrow.
No, but none of those others will be.
I'm saying, that as long as you accept that there will be other businesses in that area at some stage.
Yes, absolutely.
No, that's good. We have to be careful, outside of the hearing. It's some of your stuff you talk about, and it does lead into vulnerability in that, but does, other people, I guess you pick up on the support issues through Food for Love, but when people are spending a lot of money on alcohol but can't buy food, it becomes a real concern. Yeah.
And they certainly are.
Okay. Thank you.
Thank you for that.
Thank you.
Chair.
Would you like to swear an oath or affirmation? I'll just invite an affirmation, it's just affirming that you're righteous. Affirmation. Do you solemnly, sincerely and truthfully declare and affirm that the evidence you're about to give touching on the matter before this committee will be the truth, the whole truth and nothing but the truth?
I do. Sorry, I've just got to get over my nerves, settle myself.
Just relax.
So really a lot of the things that I would have said have been said by the last two speakers. And I think they've covered it really beautifully and really well. As an introduction, my name's Hawea. I've lived in Hawea for 48 years. The family's been there forever. I've brought up 4 kids and all my grandchildren live there. Well, actually, they've all just gone overseas. I feel like the community has not really had any chance to address this issue. All the way along from special housing area to a local shopping centre area being decided. And this is our actual only chance in a long time. When the SHA was talked about in council, council had a lead policy that they reviewed on the 8th of August in 2019. And in that, they said that that SHA had the goal of providing affordable housing and fostering a stable, family-focused residential community, supported by appropriate community facilities. Now, I do not think a liquor store at the entrance to a new community that is establishing itself is a community facility. I would even question the validity of the applicant, that he would even think about applying for a liquor licence. What does that say about him, morally, ethically? That you would put a liquor store in a new community that is establishing itself. We don't actually need, as the other woman said, we actually have enough to supply the community. Now, this has set up this whole area as a residential. When it was first mooted, I really thought, oh my God, here we go. How is expanding? Over 47 years, you actually have to change your attitude. But I've been down there. I see kids playing at the park. There's a wee caravan with food. And you walk around there and community is being generated. And this is like a slur on the landscape, that it would even be considered. And that's why I question the moral values of the applicant, that they would even think. And I realise that I can't question the moral values in relation to this act. But as a person, as a human, I'm questioning them. That they would even think first about commercialisation of this sort, over and above who's going to be living there, what's going to be happening there, what kind of a community is going to be there. All these people are here, the 530 objectors. They may have followed a template. They might not have had the energy, the effort, the knowledge, the time to write a submission. But they wanted their name down there to be counted because of their humanity, because they don't want this. Everybody here has put in time. We shouldn't even be here because the applicant shouldn't have even applied. Sure, he's allowed to. But I just think it's disgusting that somebody thinks they've got the right to put liquor in a fledgling subdivision. Now, the Act 105 actually talks about amenity. We've already gone through the whole thing about playgrounds, bus stop, children walking. I think that's about all I have to say. I just find it incredible that we're even here, that we're even talking about it. It's like you can bring up all the precedents, you can bring up all the legalese, but the actual reality is that this is a residential subdivision set up under SHA. The median house price here is 980 something thousand. Now that's on Trade Me last night, over 18 properties. Now you tell me that young people are not financially under stress when they have got high mortgages, living in this high cost society. And as the last speaker just said, when that alcohol outlet is just a quick walk away and you are feeling that stress, what do? You walk down and get another bottle. What's the applicant going to do when Lyle goes there 3 days in a row and buys a bottle of whiskey? And then he goes back for the next 4 days. There's nothing there to stop you. But nobody knows what's going to be happening at your house. So I object most strongly. I think Hawea has always had its own character. It's always been Wanaka's baby brother. And I think that we need to be able to continue building that identity and character without this liquor outlet being in the centre of a residential area.
Yeah, thanks for that. I guess where I bought my whiskey and where I drink it, it could be happening anywhere in the area, but yeah, I take your point. You've been 47 years, you've obviously seen a lot of change out there, and as you know, with the SHA, there was a fair bit of opposition to that happening there then too. Things change in the world, change in New Zealand. So you accept things don't just stand still?
Sorry?
You accept that things don't just stand still in communities, we're growing communities?
Definitely.
So are you saying that, we've asked this obviously for other witnesses, that there should never be an alcohol outlet out there, or are we just talking at the moment because there's no other commercial buildings? I think what we're dealing with is actually
like at this present time.
At this present time?
At this present time, there's 3 outlets. Yep. The supermarket does not sell spirits. The shop does not sell spirits. The pub sells spirits. This place, what would they sell? Spirits and wine and beer.
Yeah, yeah. No, I understand all that, yeah.
And I see that with the SHA and the intent of what was written and what was talked about, you were there, you will know, and also the...
No, sorry, I wasn't there. There was a short time I wasn't on.
Right. And also with, you know, the Sale of Liquor Act.
Yep.
There should be, and there is, a protection there for the amenity and for the safety of these communities. We are going to have an influx at Christmas. So that means you will have an influx into that subdivision. Oh, let's go for a drive around there. You know, you get hooning around perhaps at Christmas time.
Yeah, I understand.
They may do that anyway, but
yeah.
The liquor is an attraction.
Yeah, well, that's right. Well, it's being a very attractive place, you're going to get people coming in, and I don't think, yeah, okay, you've made the point. It doesn't just have to be about alcohol.
I think that the residents would actually, you know, when it was rezoned without any input as a local shopping centre, that it would have been looked upon as being small shops, restaurants, cafes, community services, not a liquor store.
What about a Foursquare with an outlet or a cafe with an on licence?
That's an entirely different thing, really.
Is it? It's still an outlet for
Well, they're
alcohol.
not.
It's still an additional outlet. You, and
You're
you
talking
cited
about
the
a
people that
cafe
are
where
going
you can
down.
actually-
Sorry.
You're talking about a cafe where you can buy a beer?
Well, you might be able to buy spirits, non-licensed.
Yeah, but you can't take them off site.
No, I realise that. I'm just
Yeah.
saying it's another liquor outlet and liquor licence. Foursquare with.
But that's more a social thing.
Okay. So being able to go down and buy a bottle of wine at the bottle store, going home with a nice dinner with your friends, that's a social thing. Rather than having to get in the car and drive to 2 kilometres.
I think the last speaker actually dealt with that quite well.
Yeah, I know. Sorry, we're not going to get into argument. I just trying to get some a perspective on it. We're here, and I understand exactly what you're saying, but just as long as we realise things don't just stand still, and there is, and you know, the question could be asked. I know 500 odd submissions. We'd be interested to know what the other 1,500 out there think. They could have spoken up, but they haven't. You got any feel for it?
I think that there's so much happening at the moment in this world. People don't have the time or the energy to actually absorb exactly what's going on around them, to either listen to the radio or read the paper or the local rag or whatever. They're just working. They're just paying their mortgage.
Yep, I agree with that.
And so 1,500 people might just be living their everyday lives without.
Okay. Thank you. That was a really good submission. Thank you.
Thank you very much. Thank you. Next one on the list is Vic Urquhart. He's not here.
No.
Oh, I beg your pardon, sorry. Mariana Champion? Oh, Vicky McDermott.
Do we have Vicky McDermott here?
No, she's just done it. Vicky McDermott here? Yeah, Mariana Champion, please.
I think there's a number of people that are waiting for school to finish before they, including Anya, who's Mariana's daughter.
Okay,
So if we could reorder that, that would be helpful.
right, then there's the next one, Alex Watson.
We're way ahead of time.
Yeah, Alex Watson here.
Walton.
Walton, I beg your pardon. Paula Mitchell.
So
Yeah.
Alex Walton. Thank you.
Yeah, we're ahead of time, she said.
Yeah, well, we have a break.
Well, I know we can do her, but she
Yeah.
I'm saying these others,
Alex.
were expected to take her.
Alex Watson?
Alex Walton. She's number,
So I believe that Chapman's, I believe that Anya is a child who wishes to give evidence, which is a bit of a first. And I assume that she was booked in, I think, at 3:30, and so it's about being after school for her, so she didn't have to give up school to cut. Although I'm sure she would have found this very educational.
okay.
Affirmations. Do solemnly, sincerely and truthfully declare and affirm that the evidence you're about to give, touching on the matter before this committee, will be the truth, the whole truth, and nothing but the truth? Yes.
We have your written evidence
Great.
that we've read, so.
I'm just going to pour water. I am quite nervous with public speaking, so. Thank you for having us here today to speak. We really appreciate it. Okay, so my name's Alex Walton. I'm a full-time resident at Lake Hawea. I live and work in the community. My daughter goes to school at the local school, and I'm actively involved in our community through volunteer work with the school and community groups. I also live just down the road from the proposed liquor store. And I want to make it clear, I'm not anti-alcohol, I'm not anti-development, and I'm certainly not anti-people's choice. But it's, we already have plenty of choice to purchase alcohol in our community. We've got 3 alcohol outlets. 100% of our retail stores already sell alcohol. We can get it delivered to our door through online supermarket sales. We're not limited by choice.
No one's rights are being impinged by not having the store in our community. It's not going to add any value. I'm concerned about the oversaturation of alcohol supply in our small rural community as it is growing. We need stores that add value to our community, places of community connection, essential services like healthcare, social supports. You know, there's not a police service out there, so there's nothing that mitigates or balances the harm that a store that sells only alcohol that can bring to our community. I think I speak for many that those are the concerns that we have. We don't have the infrastructure there yet. It's growing, but it's not there yet. And I think this decision needs to be made on what is there at the moment, not what's happening in 5 years' time or 10 years' time. It's what's happening right now. It's the timing's not right, the location's not appropriate. I want to speak to public health and safety. There's a lot of evidence nationally, internationally, and locally in Wanaka that the harms that we see from alcohol, it has negative impacts to mental health, to physical health. We have an overburdened healthcare system at the moment. There is increased risk of family violence with both the frequency and severity of the violence. We know family violence occurs in our communities. There is an increase in crime and antisocial behaviour and dangerous drink driving. We've seen, you know, you just need to drive around the Hawea community at the moment and there's burnout marks on a lot of those main roads. I don't know if you guys have been out there or seen them, but there is antisocial behaviour happening, there is dangerous driving happening, and we know that there's plenty of evidence that supports that increased access to alcohol directly correlates with increased risk of dangerous driving, criminal behaviour, antisocial behaviour, and family violence. Location and signage. The proposed store will be at the entrance to Longview. It's basically the gateway to a residential community. The signage will be highly visible to those travelling or walking in those areas. School buses will be going past there. It's close to a playground, a school bus stop. It's close to a proposed early childhood centre and church. The Ministry of Education has already flagged a couple of years ago that they're intending to relocate Hawea Flat School to Lake Hawea. And multiple developers have earmarked sites that are close to this liquor store that they see that the new school could sit in. Many in our community are concerned that the store signage is effectively, it's super liquor. That signage is effectively a permanent advertisement for alcohol. That in itself, you know, there is evidence around how advertisements for alcohol impacts drinking behaviour and how it normalises alcohol consumption for vulnerable groups, for young children, for teenagers that will all be coming in and out of this area frequently because of the residential nature that it sits in. Again, what message are we sending to our children and our families? It is concerning. I think overall declining this application, it causes no harm. No one's lives will be worse off because of declining it. You won't make as much money, but you know, no harm will be caused. What we're asking is just to put a pause on it for now, like perhaps in 5-10 years' time when the projected growth is there, you know, revisit it then, but now it's not the right time, it's not the right location. It's not personal, it's just not right for our community. Thank you for listening to me today. If you have any questions, I'm happy to answer them.
Thank you very much. Very well put. Any questions?
Yeah, thanks for that. Yeah, well, I think it might be the first time I think we had someone live quite close to the site. Where do you live?
I'm on Cemetery Road.
Oh, you're on Cemetery Road?
Yeah.
Okay. So a lot of talk about the burnouts and antisocial. Can you go a bit more into that? What other major issues out there with antisocial behaviour at the moment from your experience? What do you witness?
Well, so on Cemetery Road, we often hear cars driving past at high speeds. That happens. It does pick up around summertime when we get an influx of
visitors to our community, and I know that correlates with the issues they see in Wanaka with an increase in crime, drink driving, you know, similar issues. Also, I think family violence is another key concern. There's no support services out there.
So, do you go walking around the streets of Longview at all?
Yeah, there's a playground there. My daughter goes to the playground.
Okay.
Yeah.
Is there any, do you see any issues with litter or other problems around that area or not?
No, I do see a lack of rubbish bins, and I know there is, you know, in areas where, like perhaps more towards the lake, where there is closer access to alcohol outlets, we do see higher, you know, more alcohol-related litter.
Yeah. So, I know your children go to school.
My daughter does, yeah.
At Hawea Flat, is it?
Yes, she does.
Okay. Catch the bus?
Yes.
Okay. Are there many students or people, young people from there going to the high school yet?
Yeah, there's 2 busloads and the buses are overcrowded.
Okay. From Longview?
From Lake Hawea.
Lake Hawea, yeah,
and the
okay.
buses are designed that they go in and out because of there's only 2 buses. Okay. Our population's growing, more and more students will be using those buses.
Understood. Yeah, right. Thank you. Just wanted to it's good to get a bit of a feel for the definite local knowledge of what's happening.
Yeah. Something you mentioned when I sat in earlier, Lau, was you said, where do we draw the line? And it was when you were questioning someone from health over there. And I would like to ask you the same thing. Where do we draw the line with approving more and more liquor stores when we don't have the infrastructure yet in place? I think that's what we're all here, is to draw the line and to say it's not the right time and it's not the right place. Yes.
Yeah. Well, I understand what you're saying. You might a lot of outlets look at it geographically, how far away they are, things like that, and a lot of case law to go by. It's not an easy one, but it's something we are required to do under the legislation to weigh it all up.
Yeah.
And that's why I was quite keen to hear from Medical Officer Health, you know, because the consistency and how you do assess these thresholds, but like you said, we've got to do it case by case. So
case by case, and we do
look
need to
into
draw
it,
the
and
line
that's why we're
somewhere.
hearing all this information now. It's good to
Thank you.
understand
Yeah.
what this case looks like.
Yeah.
Yeah, thank you.
Thank you.
And we do thank you for your input.
Thank you very much for listening. I really do appreciate it.
I think we'll just take a comfort break for a quarter of an hour. Back in, and then we'll be back in here at 2:15. Oh dear. Okay, everybody, good afternoon again. We're calling Paula Mitchell.
Would you like to swear an oath or affirmations? So, on the Bible or just affirming?
Oh, just affirming, yeah.
Do you solemnly, sincerely and truthfully declare and affirm that the evidence you're about to give, touching on the matter before this committee, will be the truth, the whole truth, and nothing but the truth?
Yes. I might stay standing, shall I? You sure? Okay, just checking. Okay, cool. So feeling very nervous, so questions at the end, be nice to me. Kia ora koutou, ko Paula toku ingoa. Hello, my name is Paula Mitchell. I'm here to object for the alcohol off licence for the, well, we all know why we're here. Note that my submission that I put through was well referenced with quality sources, 2 pages of references for a 3-page submission. I'm here not to speak just about what I want, but I'm here to speak up for our community. I'm a Hawea community member. I've lived in Hawea for 7 years with my family. I see the daily challenges and the strengths of our community. The issue of a liquor outlet goes beyond my personal preference, and it's about protecting our community's shared values and well-being. I believe that decision makers must listen to the people who actually live and raise families here. Despite what deprivation index we've been allocated, Hawea, in particularly the Longview area, includes a high concentration of affordable housing and is home to many individuals and families who are vulnerable. Hawea is the more affordable place to live in our district, with houses being 55% cheaper than our neighbouring Wanaka. That's reference. The proposed liquor store site is within the Longview subdivision, which is approved under the Special Housing Area Guidelines to fast-track affordable housing. This subdivision has around 480 sections, 58 of which are owned by our local housing trust to provide stable homes for families unable to afford their own. A large body of research shows that lower socio-economic areas often have a higher density of alcohol outlets. Last year's press release of the QLDC Quality of Life Survey states 25% of residents report having no disposable income, and that's an 8% increase on the year before. That is one in 4 people that do not have any disposable income. 4% cannot meet their basic needs. These residents are more likely to be women under 39 and who are caring for children. This is our community. To place a liquor store here is not community support, it is just predatory. Hawea already has 3 liquor outlets for a population of only 2,432. Even looking ahead at the projected population in 5 years, it is just 3,056, and in 10 years, 3,753. These figures are predicted by Queenstown Lakes District Council using data from Stats NZ, QLDC consents, rating data units, historical ratios. These are reliable stats put out by QLDC and are used for such things as long-term plans, master plans, and spatial plans. This information is publicly available. You might find stats that show a greater future section of, future section numbers, like section numbers, but don't be fooled, that is just developer marketing. The applicant is just twisting unreliable information to improve their case. The information is not carefully predicted population growth data drawn from reliable sources. Research clearly shows that a higher density of outlets is linked to more antisocial behaviour, alcohol-related injury and deaths. vehicle accidents and family violence. That statement was my most cited statement, so without even trying, I found 5 sources. The proposed site is directly adjacent to a school bus, a children's playgrounds, and spaces that are used daily by families and young people. Hawea has attracted many young families due to its affordability. The primary school now has over 400 students. Preschools have waiting lists. The school bus runs 2 bus routes into Hawea for the Mount Aspiring College. A significant proportion of our community is under 18. For children living in Longview, this store would be unavoidable. They would pass it multiple times a day, to and from school, waiting for the bus, playing in the playground, heading out for after-school activities. With prominent signage in a standalone building, they could see the words super liquor 8 or more times per day. Research shows that higher exposure to alcohol marketing is linked to young people starting to drink earlier and in more harmful ways. Our tamariki are our future, and we cannot normalise alcohol in this way. Another important demographic is our Māori community. Lake Hawea and Hawea Flat are the second fastest growing Māori population in our district, from Stats New Zealand. It is well established that Māori experience a disproportionate harm from alcohol that includes health issues, violence, social disruption, even when drinking rates are the same or lower than non-Māori. Again, without even trying, I got 4 references for that one. These are the most vulnerable groups in our community. We need infrastructure that protects well-being and not threatens it. I urge decision makers to consider the long-term impact this business would have on our health, safety and cohesion of our community, and prioritise our community's well-being. Other councils have done this. Kaipara District Council for the town of Ruawai, Whakatane District Council for the town of Tiko, and Christchurch City Council. They all successfully declined applications on similar grounds. Please listen to our community, hear what we're saying, and decline the application. Thank you.
Thank you. Thank you very much.
Any questions? No, thanks for that. Sorry, how long have you lived out there?
Well, 7 years straight, but I did a spell in town and then I lived there before that.
Do you live in Longview? Or?
No, I live on Nickel Street. Yeah. My son goes to the playground in Longview all the time.
So, you've experienced obviously the change in the growth of Longview there?
Yeah, absolutely. Yeah.
How did that affect the community, the existing community?
Apart from the sewage problem, I get the growth I haven't noticed. I don't know what you're asking.
Well, what changes then? I know one thing that's changed. You've now got a supermarket with an off licence.
Yes, yep, we've got a supermarket, which is great because there's no public transport out there. And so, yeah, definitely to be able to go down to the supermarket and get toilet paper is awesome.
It's got an off licence, you have no problem with that?
No, I don't know.
So that came with growth and the change of the community. Do you not see that sort of change continuing with future growth? I agree with your numbers. So you don't expect to see something similar happening out at Longview?
I guess what my written submission is and the points that I touched on here was it was more about that oversaturation of alcohol outlets. So sure, yeah, we've got 3. Do we need another one? No, we don't. And that goes back to that reference material that I put in my submission about what happens when there's more alcohol outlets per capita. Yeah. And then obviously it all relates, right? The vulnerable community, etc. The location. Even though
the numbers, the increase in population over the next few years, I agree. It's more reasonable around up to 7,000, 3,700. That obviously changes the statistics. Okay, so what I'm saying is the number of outlets for the population in the future could change. Yep, okay.
Yeah, I guess we're making a decision for the time now, though, right?
Yeah.
You look at Timsfield, and Timsfield, that's stage 2 of Timsfield, because I lived there prior. You know, they were selling them, right? And then it was like 6 years, and they didn't release the next stage. So we're making a decision for what that population is now, and also what that QLDC population data shows, not what potential Longview development shows.
No, I understand, I agree, you work off the data, and we know that there are, the Timsfield's releasing the next lot soon and things like that, so yeah, that's good. Okay,
Yeah.
thank you.
Oh, sorry, one more thing. Yeah, can I add that in? I was just wondering, you mentioned before actually for Vicky, and you know, like, so 500 people submitted, what did the other 1,500 say? Well, a lot of them would be children, maybe 25%, so they're not going to say anything. So that brings it down. But even if you looked at the population data, if you were doing a scientific experiment and you wanted it significantly significant, which is what our quality of life and all our other stats are based on, that those 500 submissions versus our population would have a 99% confidence rating. That's just some scientific maths there. Oh, you're so welcome.
Yeah, I'm really a fan of science.
Yeah. Anything else, team?
Thank you. Thank you very much.
My colleague covered it quite well. Thank you.
Who next have we got? Tom Cull? No.
Tom Cole?
Mariana Chapman not here yet?
No, she's coming after school.
Andre Mayer? What number's he? 15.
Do you swear by Almighty God that the evidence you're about to give touching on the matter before this committee will be the truth, the whole truth, and nothing but the truth?
I do. Mr Mayor, we've got 2 evidence bundles from you. One dated the 23rd of September and the other the 2nd of October. Which one do we deal with, or do we deal with both?
The 2nd of October.
Thank you. So we've read your notes, comprehensive notes, so we'll invite you to speak to those.
Thank you. My name is Andre Meyer. I have lived in full-time in Hawea for almost 10 years. I currently serve as chairman of the Hawea Community Resilience Group and have previously served 5 years as president of the Lake Hawea Community Centre. Before I speak to the legal aspects of this case, I wish to explain why the object of the Act to minimise alcohol harm or alcohol-related harm means something very real to me. My mother grew up in a house or in a home where alcohol caused serious family violence and abuse. It affected her entire life, and as a result, our family moved far away to build a different future. That experience is why I respect the law's safeguards. They exist to protect families and communities from the consequences of unsafe or poorly regulated alcohol use. I share that only so the committee understands why I approach this issue with care and why I believe the legal process must be followed exactly as the Act requires. As confirmed by the Land Information New Zealand Record of Title Identifier 119274-2, dated 12th November 25, the registered owner of 107 Longview Drive remains Universal Developments Limited. Based on statements by the applicant's representative, the land is understood to be subject to conditional sale and purchase agreement through which the applicant appears to exercise only limited control. This distinction is significant because the way the application has been presented has created the impression of ownership and development authority that does not in fact exist. By lodging and promoting the building resource consent in its own name, the applicant has projected a sense of ownership and certainty that has discouraged other potential operators, shaped community expectations, and prevented more appropriate or community-aligned businesses from considering investment in Hawea. This site is a prime commercial location at the entrance to a substantial subdivision, and how it is used matters greatly to the community's long-term development and character. Allowing one party to secure a perceived monopoly position through presentation rather than ownership undermines both market fairness and public confidence. The conditional agreement effectively enables land banking. By advancing a licence application over land it does not yet own or occupy, the applicant is attempting to bank a potential licensing position on undeveloped land. Such conditions distorts competition and restricts genuine local development to the detriment of the community. Parliament has already recognised that harm caused by this behaviour, similar practices were explicitly prohibited for supermarkets under New Zealand grocery sector reforms, where land banking was found to limit fair access and entrenched market advantage. The same principle applies here. The Sale and Supply of Alcohol Act 2012 does not provide for speculative or pre-construction licensing. Licensing must be based on existing lawful premises, not on conditional contracts, paper ownership or strategic positioning that prevents others from participating in the local economy. Section 100F of the Sales and Supply of Alcohol Act 2012 is a mandatory legal requirement, not a discretion. It provides that the District Licensing Committee must not issue a licence unless the building in which the premises are situated meets the requirements of the Building Code 2004, including the possession of a Code Compliance Certificate, CCC. No such certificate exists. No evidence of one has been produced. There is no completed lawful building at 107 Longview Drive. I personally visited the site yesterday, 12th of November 2025, and as accompanying photograph shows, the land remains an open paddock. Because this mandatory condition cannot be met, the committee has no jurisdiction to grant the licence. Any attempt to do so will be contrary to the Act and therefore unlawful. To put it plainly, a licence cannot be issued to a paddock, not to a plan, not to a CAD drawing, not to a blade of grass. This law requires an actual, completed, code-compliant building before any licence can exist. This point is decisive. Unless and until a CCC is issued for a completed building on the site, the application cannot lawfully be approved, regardless of any other considerations. It has been suggested that a liquor store or a liquor outlet in Hawea is inevitable. That assumption is not supported by law and must not influence the committee's consideration. Each application must meet statutory requirements at the time of decision. The Hawea community will always have a say in its future when it comes to the sale and supply of alcohol, and that right is substantive, not symbolic. The applicant's Super Liquor Remarkable Park outlet in Frankton was recently ram-raided, as reported by the Otago Daily Times on the 11th of November 2025.
This incident highlights the real security risks associated with this type of business. Yesterday, counsel for the applicant stated the police responded quickly. Those risks are far more difficult to manage in a small community such as Hawea. As I understand, it would be reasonable to expect that response times to incidents in Hawea are likely, on average, to be longer than in larger centres where super liquor outlets are typically located. Increased crime, or the increased risk of crime, is one of the matters the Act requires to be mitigated, yet those protections cannot be adequately ensured in Hawea under the current proposal. You may recall yesterday, counsel for the applicant stated that good character must be assessed independently, including qualities such as honesty. I remind the committee that the applicant's Form 4, dated 1st of April 2025, at question 2D, what right does the applicant have to occupy the premises, states, applicant owns the site. And under expected opening or takeover date, it states 31st of May 2025. Both statements are inaccurate. The first was misleading and the second could not be possible or possibly have been true given the construction had not commenced. The form itself states that applications for new licence should be lodged at least 6 weeks prior to the anticipated opening or takeover date. It is clear that the applicant simply inserted a date to satisfy that filing rule, creating the appearance of imminent opening that never existed. Under oath, Mr. Mackay repeated that misleading narrative, saying the outlet would go right smack bang in a commercial area, and it takes some confidence to put a new business in a vacant paddock. That comment was later printed in the Otago Daily Times today, confirming that the applicant's own evidence and public statements acknowledge they are proposing to license a vacant paddock that they do not own. Mackay's statement that it takes some confidence highlights the contradiction. If the applicant truly had such confidence, Applicant truly such confidence, they would have purchased the land or commenced construction. Instead, no real financial commitment has been made. To describe that as confidence is simply misleading. These representations in the application form, in sworn evidence and now in public record, create a misleading impression of ownership, investment, and certainty that does not exist. An experienced operator such as the applicant understands the licensing process and how early statements can shape perception. By presenting ownership, certainty, and confidence they did not in fact have, they have manipulated the process and set the tone for their own narrative and agenda. This is not honest conduct. My observation of this process is that it appears not to be against the law to file false or misleading statements on Form 4, because if it were, we would not be here at this hearing today. The application would have failed the moment those misstatements were identified by the District Licensing Committee. However, I refer to Council's own words that good character must be assessed independently. On that test, this behaviour fails. Honesty is not an option. It is the foundation of suitability under Section 105(1)(a) of the Sale and Supply of Alcohol Act 2012. Candour means the quality of being open, honest and transparent in what one says or discloses. New Zealand case law, for example, Lou versus Police and Capital Liquor Limited versus Police, confirms that honesty and full disclosure are central to the test of suitability under section 105(1)(a). If an application withholds, distorts, misrepresents material facts that fail of candour alone justify declining a licence, even if no other criteria are breached. I wish to reference case law Lou versus Police. It's a High Court decision appeal from the Alcohol Regulatory and Licensing Authority. Judge was Justice Clark. The court confirmed that suitability under 105(1)(a) requires a full assessment of the applicant's character, reputation and honesty, not just compliance history. Justice Clark stated that candour with the authority is fundamental. A lack of frankness or the provision of misleading information goes directly to honesty and therefore suitability. The appeal was dismissed and the High Court upheld ARLA's refusal of the licence on that basis. Capital Liquor versus the Police. Court was the Alcohol Regulatory and Licensing Authority. Judge S.G.O. Driscoll, District Court Judge, and Mr. P.S. Jones, QSM. The ARL confirmed that honesty and openness are integral to the concept of good character. The authority held that an applicant who misleads or withholds relevant information from the committee or the police demonstrates a lack of integrity required to hold a licence. The failure of candour alone justifies declining the application. Finally, if in their closing the applicant chooses to respond in detail to the matters I have raised, I would suggest this in itself confirms the importance and the validity of those points. Issues that are immaterial are not usually rebutted. The fact that these matters attract such a response only reinforces that they go to the heart of this application and should be taken all the more seriously by the committee. Now, in summing up, today I speak not only for myself, but for many in our community that cannot appear. Our school principal, faith healers, and others whose professional roles prevent them from speaking publicly. I have spoken with them personally. They share these concerns. The hearing is about more than one licence application. It's about whether the law will be applied as Parliament intended, fairly, transparently, and without favour. Public confidence in that fairness is as important as the decision itself. Our community must be able to see that the process was impartial and that every participant was treated equally under the law and as required by both the Sale and Supply of Alcohol Act 2012 and the New Zealand Bill of Rights 1990, which provides that every person that has the right to the observance of the principles of natural justice by any tribunal or public authority which makes determinations affecting their rights or interests. On the facts before you that require requirements of Section 100F cannot be met. The applicant does not own the land. The building resource consent, although granted, has been used in a way that creates the impression that the applicant already owns and controls the site. By lodging and promoting that consent in its own name, the applicant has projected a level of authority and certainty that does not in fact exist. In reality, there is no building. There is no co-compliance. These are not technicalities. These are mandatory preconditions set by law. To issue a licence in these circumstances would be to issue a licence to a paddock. The Act simply does not permit that. As the applicant's own representative, Mr. Mackay, confirmed, issuing the licence would trigger the unconditional sale of the land, meaning that the property developer, Mr. Lane Hocking, could enforce the contract and require settlement, transferring title to the applicant. The dilemma for the applicant then becomes immediate. Do they commence building on that paddock, knowing that an appeal by the objectors is certain and that there is a strong confidence in the legal points raised at this hearing? If the decision is appealed and overturned, the applicant will find itself exactly where it did not want to be, owning a paddock in Hawea with no liquor licence and no prospect of one in the near future. I ask the committee to consider carefully, by granting a licence today, would you truly be doing the applicant any favours, or would you be exposing them to unnecessary financial and legal risk that would have been avoided by applying the law as it stands? Section 100F, and declining the application until a compliant building exists. The community has acted in good faith, following every lawful process available to it. We now rely on the committee to do the same. I note that Mr. Cox, a member of this committee, was quoted publicly as saying that decisions must be made strictly according to Section 105 of the Sale and Supply of Alcohol Act 2012. On that point, I completely agree with him. Section 105 sets out the criteria that must be satisfied before a licence can be granted, criteria that are not optional. Applying the Act as written, as Mr. Cox himself has stated, leads to only one conclusion. For those reasons, the only lawful outcome today is for this application to be declined.
Thank you very much. Any questions?
Yeah, thanks, Andre, for that. Just going back, I totally take on what you've said. Just going back to your comment about land banking. Now, the applicant, as we know, doesn't own the land. We've got a conditional agreement on the land subject to the outcome of the application. You say they've land banked, but they've only got a condition on a certain part of that land, not all that commercial land. So I don't understand what you're saying, that it stopped other businesses from going in, buying land off Universal and starting a business, whether it be a medical centre, hairdresser, doctor's studio. So the way you said it, you sort of indicated that all those businesses have been turned off because of this one conditional offer on a corner of that.
No, the object of the applicant was to convey to the market that they were in control of that area. That is a prime location. It sent a direct signal to all other liquor stores. Don't look at Hawea. We've got it sewn up.
It didn't send a message to the...
I haven't finished.
Oh, sorry. I apologise.
The second message it sent to the community is, this is what you have to put up with. Meaning, if you're going to be a neighbour, if you're a church, if you're a health centre, you've got to live beside a liquor store. You can't say, and I can't say, how many people were put off by adding value to our community and buying a section there to develop those services, because the market was hearing this liquor store was in control. And that was far from the truth. We need to focus on Section 105, 1A, which is about being truthful. Secondly, we have to focus on Section 100F, that talks about the land.
Yeah.
I don't think there's any other thing we need to talk about. Those two are enough for you to say no.
Okay, I understand that, but I'm still not clear that by having an option on a part of a commercial site, you say stops other businesses wanting to invest and set up a business there.
Absolutely. Why wouldn't you?
Liquor stores, I'm talking about other businesses.
If you were trying to set up a doctor's room next door, do you think it's an appropriate site to be right beside a liquor store?
Oh, yes, definitely right beside the residential area. It's in the community.
No.
I'm not arguing. I'm just saying.
You are arguing.
Okay, I won't argue.
He's right.
Thank you. You've told me lots of times that you're right. This time I'm telling you I'm right. Okay?
Okay, all I'm trying to find out that, okay, so.
Land banking is illegal for supermarkets. The government has ruled against it.
Yeah, okay, but it doesn't stop other businesses buying, investing there, and we've got, I can give you an example of a New Life church that's set up right beside a super liquor in Wanaka. Hang on, so.
No, that's false. That is false. That is false. Okay? When did the church open? 2018. When did their shop open? 2008.
That's right.
That's right.
So the church chose to start up beside the liquor store.
In an industrial area.
After the super liquor. So what I'm saying in Hawea, the super liquor's there, you're trying to tell me other businesses won't set up beside it.
That's not a fair comparison. That was a building that was a commercial building. They decided to use it as a church because they didn't have to build anything, right? And I think that's being unreasonable. You've got to concentrate on the facts of law, and that's got nothing to do with it. The fact is these people colluded on the application to give the market a clear message. They had control. That stopped any other alcohol store taking that position. It could have been Bottle-O or Liquorland. They sent a clear message to all those competitors, don't come to Hawea, we own this and have got it sewn up. That was lies, period, right?
Okay, forget about liquor stores. Say super liquor was there. They've got a corner site. I'm looking at investing in Hawea and I want to build a cafe. I want to build a, bookshop. How is them having a conditional offer there putting me off buying the section next door and setting up Paper Plus?
Totally irrelevant, and I'm not going to answer it.
Okay. I'm sorry, I was just trying to address your comment about the land banking,
Land banking allowed them to minimise their financial risk, period.
You've made your point.
Thank you.
Any questions? No, I've certainly got none to ask.
Would the chair mind if I placed a copy of what I've said with you as evidence?
Yeah, don't mind at all. Thank you. Have you got 3 copies? 4. Oh, good.
Thank you.
Thank you. Thank you. Thank you, Mr. Mayor. Right, who have we got? Tom Cull? No? Mariana Champion here yet?
Mariana and Anya are on their way from school.
Okay.
So they'll be here shortly.
Now, could move in tomorrow's list if people don't mind, is Annamet Sorensen, Cameron Riley, or do you want to do your report after? Or do you want yours left to the end? Yeah, we'll leave to the end. Yeah, we'll adjourn to the till the others turn up.
I think they'll probably be within 5 or 10 minutes.
Yeah. Okay.
So we've got a quarter of an hour?
Yeah.
We'll come back in a quarter of an hour.
Thank you.
Sorry, I should
know. Good afternoon again. Is the champion family available?
Yes, we are here.
Great. Come on down.
Come down as well. You're all in the benefit you have the whole day to get used to this, whereas we're just tuned in.
That's right, no rush.
Would you like to swear on oath or affirmation?
Affirmations, please.
Affirmations. Do you solemnly, sincerely and truthfully declare and affirm that the evidence you're about to give, touching on the matter before this committee, will be the truth, the whole truth and nothing but the truth?
Yes. Right, is this on or?
Yeah, perfect. Okay, so I'm Mariana, and we moved.
Closer, sorry. Just pull the...
Shall I move this closer?
Thanks.
Is that better?
Yeah, thank you.
Okay. So my name's Mariana, and I have a family with 2 daughters and a husband, and we live in Lake Hawea. We moved to Hawea about 5 years ago, and we chose to live in Lake Hawea because it was a small, safe community for our family to grow up in. A couple of things I would just like to look at from what I put in is that one of the key aspects of the application was the sponsorship for sponsoring sports events. I feel that this is actually a way for the business to promote themselves, and it's actually not really doing their bit for the community. There's actually a private members bill that's gone into Parliament that is to end all alcohol sponsorship in sport. The unfortunate thing for this is that that bill can't be looked at or passed until it has been drawn out of the ballot. But in quite a lot of countries around the world, sports sponsorship regarding alcohol is actually being banned. And that was in 2016, so we're really behind that. And that was in Norway, Denmark, Portugal, France, just to name a few of the countries that are doing that. Because by sponsoring children's sports teams is actually normalising drinking, and what we actually want to do is we want to show children that we shouldn't be really drinking, and we want it to be something that is not normalised within society. It's also stated in the applicant's statement that that it is far away from residential properties, but this also isn't true. It's on a development where there are houses all around, and the school bus gets drops the children off right near this proposed establishment. So anyone entering the subdivision from Wanaka will go straight past this building. It's also on the same street as a playground. We live across the road on the other side. We don't have a playground where we live, so in order for my children to go to a playground, they have to cross that main road and they have to go past this liquor store. And so everyone who is going into that area will go past this store and they will see it. And for my children, when they go up to the Lake Hawea store, when they go to the supermarket, none of those buildings there are actually actively promoting alcohol. You don't get there or see the alcohol until you end up inside the building. Whereas this is going to be on a main street where there is a playground just down the road. We have taken cigarettes away from the eyes of children, and we should be doing the same with alcohol. By allowing this application to be granted, we are opening the door to create an environment where it allows young people to make bad decisions. There is plenty of research that is linked between alcohol and young people making poor decisions, from drink driving to antisocial behaviour. When my husband was building our house last year, he witnessed 2 incidents, and this is just him outside our house building, where 2 cars drove past and both those cars had open bottles of beer in their hands, and these people were drinking and driving. By having this establishment, we will be increasing this happening. And for our young people to be able to leave Lake Hawea, the only option for them is to get into a car. So if you've got a 16-year-old group of kids and then someone who's just got their licence,
The only way for them to leave Hawea is to go in a car, and by having an establishment where they can purchase alcohol is increasing the risk that they will make a bad decision and they'll get in a car with somebody who's maybe been drinking. I'm strongly against the granting of this licence, and I'd just like to say that my daughter Anya was very keen to speak, and we spoke a lot about this at home, and it is not us who's encouraged her to come. She has asked several times whether she can come and speak, because for her, she feels that the people it will impact the most within this entire room are people of her age. Right, thank you. It's your turn now, Anya. You can speak into here.
Okay.
And say as much as you want.
Anya Champion. I am 8 years.
Sorry, Anya. I'll just swear you in first and then we get underway. Would you like to swear on oath or affirmation?
Affirmation.
Okay. Do you solemnly, sincerely, and truthfully declare and affirm that the evidence you're about to give touching on the matter before this committee will be the truth, the whole truth, and nothing but the truth?
Yep. Anya Champion. I am 8 years old and I go to Hawea Flat School. I strongly believe we should not have the super liquor in Longview. Firstly, it will put families in danger. Secondly, it will affect the younger people of Hawea, both as a child and when we grow into adults. Lastly, teenagers will make the wrong choices and will be able to access liquor more often and easily. I'm against this, and I want to live in a community that is safe, where I can easily make the right choices. By having the liquor store in Hawea, I am worried that lots of young people will make the wrong choices and get into lots of trouble. If you haven't realised, I'm against this.
Thank you very much. Any questions?
Oh, yeah. Thank you for that. Thanks, Anya. Anya, can you give us have you seen an example of some older children making bad choices? You got any examples?
No, not really.
Okay, I understand what you're saying. That's pretty cool. Mariana, you made a comment. I'm just trying to get a bit of balance here. I'm a driving instructor, so I deal with young people driving. You talked about driving in Hawea. It is isolated at the moment. Talk about probably getting in the car with someone who's been drinking. What about the option? The other thing is they go into Wanaka, they start drinking, then they've got to get home again. So I'm just trying to get the balance there of, you're blaming it's going to get a lot worse with a liquor store in Hawea, but do you accept there could be the same risk at the moment with having to go drive into Wanaka and then having alcohol and then trying to get home? I'm just trying to get a bit of balance here, that's all.
Don't quite know what you mean by that exactly. That my children in our community live in Hawea, and so that's where they play, where they live.
Yeah, but you're talking about the 16-year-old just got their licence, and there's always pressure on them to take passengers. Yeah. You mentioned that the liquor store there, they're likely to buy some liquor and then alcohol, and then maybe drink it, and then they'll might get people in the car with them. They'll drive off to do something. I'm just saying that's a real example. But I just want to know whether you understand that could be the same thing that happened with them, that same person driving into Wanaka and having the friends and having some alcohol.
Well, that could be, but it's really important for us to reduce those choices and those chances of that occurring, I believe.
Okay. Have you got any examples? Have you seen that happen with young people, the young drivers out in Hawea, doing anything like that?
Well, my husband saw two people drive past our door with drinking alcohol.
What were they, 16-year-olds?
I'm not sure how old they were. I didn't mention that. But we all know that children drink, and we all know that they drive, and there's peer pressure.
When you say children, you all know that children drink. What do you mean?
Like teenagers drink, 16-year-olds, 17, 18-year-olds.
Okay. Thank you.
Thank you for you both.
Thank you.
Tom Cull, is he available?
He drives a school bus.
Ah. Well, he's the last one for today. So we have a break again.
Wait for Tom.
We'll have a break, and if someone would let us know when Tom Cull arrives, we'd be grateful. Thank you.
Does anybody sort of know, as I'm looking at you, sir?
Yeah, no, we were just having a conversation. You asked me about Tom.
Yes.
I think he might be the bus driver for the next school bus, isn't he? So he'll be driving about now. Yeah. So that'll be why he can't be. He would have planned to be here later.
Okay.
So whether that can be put out till tomorrow, perhaps, not sure.
Yeah, we might see if we can contact you. Have you?
If you can't get in soon, it'd be better to come tomorrow, wouldn't it? Right? It'd be better to come tomorrow.
Yeah, I'll try and contact.
I can get his number if you want.
No, nothing. We don't want to get these people out of order, they'll all get the prick. And Wayne Morris tomorrow doesn't want to be here till 2:30. We're supposed to start at 9.
Yeah.
No, but if you need someone.
Excuse me, sir, Mr. Colin Goldthorpe, who's giving evidence tomorrow, is here and willing to give evidence now. Would you like him to do so?
Would you like to swear on oath or affirmations?
Affirmation, please.
Do you solemnly, sincerely and truthfully declare and affirm that the evidence you're about to give, touching on the matter before this committee, will be the truth, the whole truth and nothing but the truth?
I do.
Thank you, Mr. Goldthorpe. Just proceed when you're ready.
Okay.
We've got your written.
Yes, I'm assuming that you've read that.
Yes.
Yeah. And I'm assuming this is on. My name is Colin Goldthorpe. I've been a registered psychologist for about 28 years, until about 4 years ago when I stopped practicing. By that stage I was 67 and my hearing wasn't quite good enough. I've worked extensively with young people and their families in Otago, mainly in the central Otago, Southern Lakes area as part of a company called Adventure Development. I was the managing director and the clinical director and a major shareholder of the company as well as a clinician. We were funded to work with young people with alcohol and other drug issues, mental health issues or offending issues by the district health boards and by Oranga Tamariki. The company provides services in Southland, Otago and South Canterbury. Adventure development has been extensively evaluated, including a 5-year PhD study by Dr. Elaine Mossman from the School of Criminology, Victoria University, and Dr. Simon Crisp, a clinical psychologist from Australia. The program was also strongly supported by Principal Youth Court Judge and then Commissioner for the Child, Andrew Beecroft, and Jim Anderton when he was an MP. And I was extremely grateful for that support. I retired when I was 62. I spent up to 81 days a year in the mountains doing group therapy with young people working 12 to 16 hours a day. And I felt it was time for other people to take over. There were over 30 staff at the time that I retired, and there are now 76 staff in adventure development. So the demand for adventure development's services has gone up significantly. And it's one of the largest NGOs working with young people in New Zealand. In the 5 final years of practicing as a psychologist, I worked privately in Lake Hawea, mainly with adults, but also with young people. I didn't advertise, but there was a constant demand. There is the beginning of a culture change around alcohol consumption and its effects in our communities, similar to what's happened around smoking. The recent High Court case, Sing 25, which overturned the granting of an off-licence, indicates that the primary objective of the Sale and Supply of Alcohol Act 2012 is the objective of minimising alcohol-related harm and meeting the minimum legal requirements is insufficient in considering an application for an off-licence where there is significant community opposition and evidence of potential harm, and that expert advice is considered important. I'm grateful for the Communities Against Alcohol Harm group for providing a framework for making an objection. However, the statements made in that submission are entirely my own, and I consider it both vexatious and an insult, and insulting of the applicant's lawyer and the Alcohol Licensing Committee to infer that they are not. It seems that it's acceptable for one party to bring in professional assistance, but not for another. The applicants in their statements to the committee have talked about their focus on reducing alcohol harm. Mr. Christensen said they take the reduction of harm seriously. They were at pains to state that they did not sell to young people under the legal age. From over 50 years of working with young people as a teacher, a psychologist and as a parent, I'd have to comment that the applicants are delusional if they think that it's sufficient to that is sufficient to minimise the harm alcohol does young people. Young people in this area and elsewhere in New Zealand bully their parents into purchasing alcohol for them, steal alcohol, and pressure or pay legal age young people to get alcohol for them. At the same time, I've worked with lots of young women where adults or legal age young people have used alcohol to sexually abuse them. The applicant's lawyer says that generalised evidence is not sufficient. Yes, Lake Hawea is unique in some aspects and similar to other small communities in New Zealand in many other aspects. Anyone who's travelled overseas or within New Zealand will be struck by the commonalities and the differences of the human condition. I disagree with the applicant's lawyer. We should use both New Zealand and international research to inform decisions and also consider the realities of living in the Lake Hawea area in determining the likely risks of this application. About 20 years ago, there was an attempt made to work out what the cost of alcohol was in New Zealand, and it was put at about $4 billion. And I was one of those costs because I was funded. The police were another one. we were funded to try and deal with some of the harm that it was doing. The most recent, an independent report commissioned by the Ministry of Health by the New Zealand Institute of Economic Research, which prides itself on its independence, called Costs of Alcohol Harms in New Zealand, Updating the Evidence with Recent Research 2024, which is about as close as you're going to get with research. This report puts the current cost around $9.1 billion, but indicates that it's most likely to be an underestimate. Over half of that $9.1 billion is attributed to fetal alcohol spectrum disorder, and I'll come back to that, in terms of lost productivity, health, welfare and justice costs. Lake Hawea is a subset of New Zealand. It would be naive to think that there is no alcohol-related harm in Lake Hawea area, and that increasing the number and proximity of alcohol outlets in Hawea would not further increase the risk of alcohol-related harm. New Zealand research supports this view. I think the most recent paper I looked at was Hobbs, which found that nationally representative New Zealand data showed that close proximity to alcohol outlets was associated with increased crime and increased hazardous drinking. In preparation for this hearing, I went back over the case notes and assessments of the clients I worked with privately, some of which was pro bono, from my office, which is a short distance away from the applicant's proposed site. I went through 1 year's worth of clients out of the 5 years I've been practicing privately. I only worked 1 to 2 days a week. I was trying to get a life balance back again. And I worked with 54 clients in 2020, of whom 24, that's 44%, reached the criteria of hazardous drinking on the audit. The audit is the Alcohol Use Disorders Identification Test. It's a screening tool, which I then followed up with further assessment. When these 24 clients listed the issues they were struggling with, alcohol was either the primary problem or the largest contributor to the primary problem. This included a small number of referrals from the police for drunk driving, common assaults and domestic violence. Many of the 24 people had originally turned to alcohol to deal with issues around depression and anxiety. Our mental health system is better than lots of places, but it's not wonderful. And many people self-medicate. It helps them, but then it becomes the problem. The issues that these people were trying to address included, I've kind of lost my way for a minute. The issues that these people were trying to address included, as a direct result of their alcohol consumption, suicidal ideation, theft, loss of jobs, relationship breakdowns, violence towards partners and children. This is where the police weren't involved, and I didn't get that referral from them. Significant financial hardship, and for a smaller group, alcohol dependence. This included a 20-year-old who has ended up going through a residential program twice, and hopefully has made it this time. Since stopping practicing as a psychologist, I continue to get people ringing asking for help, and I can't do it because I've handed over my registration. I no longer have the professional indemnity insurance, those sorts of things. As late as a month ago, just before I left on holiday, I had someone ringing me from Canada who had originally worked with here, asking for help. There are not a lot of psychologists around. There are not a lot of male psychologists around. And there's no one else that I know of in Lake Hawea. And it's definitely getting worse as the workforce ages. We're an old group and we're dying out. But I want to come back to fetal alcohol spectrum disorder because these children never get to make a choice. They don't get to say, I'm going to drink, I accept that risk and I'll manage it. it happens to them. We don't know how many, if any, children have fetal alcohol spectrum disorder in Lake Hawea. Others may know. The shame and stigma of having a child with such a diagnosis, the thousands of dollars required to get that diagnosis, and the difficulty of accessing specialists to obtain such a diagnosis means it doesn't happen. Basically, you've got to go to Auckland. There used to be some people down in Dunedin. We do know that approximately 3,000 of the babies born in New Zealand each year are estimated to have fetal alcohol spectrum disorder. And I need to say it's a spectrum. There's a real range. For some people, it's just around a whole lot of behaviour problems. For others, it's much more significant than that. And we've had clients on adventure development who had fetal alcohol spectrum disorder. This is a lifetime sentence on the child and the family. The level of damage to the baby is related to how much alcohol and when it's consumed during the pregnancy. The damage can occur before the woman even knows that she's pregnant. And it can be a really small amount of alcohol, what we would consider to be a small amount of alcohol. 1 or 2 drinks at the wrong time. Personally, having a 32-year-old, 6'3" nephew with a cognitive age of approximately 8, and all the relationship, health, educational, and offending problems that have occurred as a result of this, I would not wish on even one more baby, mother or family in Lake Hawea. Longview is a new subdivision with what looks like, to me, from travelling past it, which I do most days, predominantly young families and women of childbearing age. In my view, the applicants, despite their protestations that they take alcohol-related harm seriously, are unable to mitigate the increased risks of alcohol-related harm in such a setting. I'll take any questions.
No, that was very good, thanks. I haven't got any questions. Thanks, Mr.
No, thank you.
Your comments about alcohol would apply anyway, wouldn't they, without this new off-licence?
Well, the problem is the increased availability, the proximity in a subdivision of young families, and where it's parked right in the middle of everybody's face. And look, national research and international research has got to the point of basically saying there is nothing, there is no such thing as safe alcohol use, because at some stage it will come back and bite you. But everyone has the right to choose their own level of risk. It's where they start to impact on the rest of us and on people who didn't get to make a choice, like those babies, that I draw the line. It's all of us, not the alcohol industry, that pays for the services, the courts, the police, everyone else. And that's why we should have a right to speak in situations like this.
No, it's fine. Thank you very much.
Sure. Yeah, just to follow up on that, you talked about all the research and all the statistics. The fetal alcohol spectrum disorder in New Zealand, you talked about possibly 3,000.
Yeah, no one knows because it is a spectrum, and some parts of it are so mild they could just simply be behaviour problems.
So there's no, I guess then in that case there wouldn't be any statistics or evidence to show certain areas where it's greater than, and sort of what I'm getting to is other areas where it's a greater problem or greater, there's more numbers of this disorder.
Well, obviously, if you're going to drink and you're female, then if you end up pregnant, as a result of all of that. And remember, we're talking about young women who are predominantly having sex while they're inebriated.
Yeah, okay. Yep.
So,
No, I'm just trying to...
And the pressure, I would say, now you asked the question, so I'm going to answer it. The pressure on young women around the Wanaka area, Hawea area, Queenstown area, to have underage sex while alcohol is involved is higher than other areas of Otago. And I've worked in all those areas. So this is a concern for me, and I'm really pleased that my two daughters didn't grow up in this community, because I've talked with the young women, worked with the young women, and seen the pressure that they have been under. Okay?
So greater than other areas in Otago, what about other areas in New Zealand? Do we have statistics to show, what I was getting at was the FASD, have you got statistics to show that there's more cases of it in different parts, geographical parts of New Zealand, and does that sort of tie in with more alcohol outlets? I'm just trying to understand if there is any research or evidence of that.
It's only starting, and the last report that came out, commissioned by the Ministry of Health, has been they tried to get as many courageous people who would admit that they had a child who had fetal alcohol spectrum disorder to come together. And that report, which talks about the need for a change in the drinking culture, talks about a need for legislation, and I agree with the applicant's lawyer. There's a lot of this stuff that needs to be dealt at the political and the legislative level. That stuff always follows way behind, and in fact it seems to be going backwards with the latest stuff around cigarettes, where the research is and where the population as a whole is. I think there probably wouldn't be anybody in this room, this is me making a bold statement, will probably get my head cut off for, there probably isn't anyone in this room who can't describe someone in their extended family or friends who hasn't been damaged by alcohol. Most of the suicides around young people happen when they are drunk. It's because of the that alcohol basically turns off our ability to make good decisions, moral decisions. And that's already starting to happen after 2 to 3 drinks. And when you look at young women, small body mass, young age, you know, a much greater effect. When you start to look at it at a brain level, what you find is the good thing now that we can actually look at what happens inside a brain without chopping someone up, with magnetic imaging and all of that sort of stuff, is that they're finding that cannabis and alcohol both produce the hippocampus, which is about here, where those two lines join. Now that's tied up with emotional self-regulation. So when you've got a young person experiencing a 15% reduction in their hippocampus, what do you think happens to their ability to manage themselves emotionally? And we know that that emotional regulation determines how likely you are to be successful in life.
Thank you.
Yeah. Anyone else?
Thank you very much.
I'll get out of your way.
What's happening, Mr. Dr. Gordon. Dr. Gordon. Have you got any matters arising that you'd like to address? And Mr. Young and Dr. Butchard. Any matters arising today you want to address, or do you want to leave it till you make your final submissions?
Closing. Oh, closing. There's nothing that I'd want to address, and I was planning on asking for closings to be submitted in a written form if that was acceptable.
Yes, of course. Yeah.
Thank you.
Mr. Young?
No, nothing from me, sir. Nothing from me, sir.
At 4 o'clock they're online.
Yeah.
Yeah, 4 o'clock, that's online.
Oh, yeah.
She's online at 4 o'clock. Yeah.
Oh, okay. Have you got...
It's online. There's a screen.
No issues for me, thank you.
That's fine, thank you. Hello, Jen, can you hear me?
Okay, can you hear me?
Sorry, this is Chris Cooney, I'm the chairman, and with me is John Mann and Lyle Cox. And I understand you want to deal with your evidence. We can't actually swear you because you're not on site.
We can do it.
Okay.
We'll do it now.
Yeah, they're going to ask you to do an affirmation.
Do you solemnly, sincerely and truthfully declare and affirm that the evidence you are about to give touching on the matter before this committee will be the truth, the whole truth and nothing but the truth?
I do.
The floor is yours, Jen.
Thank you, Chair and committee members. I strongly oppose the application for a liquor store at Longview Lake, Hawea, for the following reasons. When Longview was marketed, it was described in the media as all about community. The indicative plans included a coffee shop, a gym, a childcare centre and a playground. Amenities that foster a safe, family-oriented environment. These representations shaped public expectations and influenced my husband and my decision to purchase the property. A liquor store is fundamentally incompatible with this vision. It introduces a commercial activity that conflicts with the character and amenity values promoted from the outset. We invested in Longview, expecting a neighbourhood that prioritises family well-being, not one where alcohol retail becomes a focal point. Granting a licence for an unbuilt store in a residential housing estate undermines responsible public health objectives. It sets a precedent that prioritises commercial interests over community well-being, where there's a foreseeable risk of adverse social consequences. Alcohol retail in a housing estate will likely increase exposure to alcohol-related harm and diminish perceptions of safety. This risk is amplified by the proposed proximity to the childcare centre and playground that already exists. These are spaces where families and children gather, spaces that should remain free from the influence of alcohol marketing and retail. Lake Hawea and Longview Special Housing Estate are growing communities with young families and limited social infrastructure. Introducing a liquor store in this environment creates a risk of alcohol-related harm where protective factors are not yet established, such as strong community policing or addiction support services. The applicant argued that supervised designation and ID checks will prevent harm, but these measures only address point-of-sale compliance. They do nothing to mitigate the broader social impact of normalising alcohol in a family precinct. The presence of a liquor store changes the tone of the neighbourhood and undermines efforts to reduce alcohol harm. I do question the applicant's strong claims to community ties because genuine engagement on this proposal was largely absent. Residents were approached late in the piece, which gives me the impression it was more like damage control than consultation. Sponsorships and past involvement in other communities do not substitute for meaningful dialogue with the people that will mostly be affected by this decision. I was deeply concerned about the imagery submitted by the applicant depicting a man and a young girl associated with liquor branding. In a country where alcohol misuse is prevalent and family violence remains a documented consequence, such imagery risks normalising alcohol in a family space. And again, I stress, a family space. This is inconsistent with public health objectives and undermines community efforts to protect children from exposure to alcohol-related messaging. The Resource Management Act promotes enabling communities to provide for their social, economic, and cultural well-being. Introducing alcohol retail into a housing estate undermines these outcomes. While the applicant highlights economic benefits and job creation, these do not outweigh the social harm and loss of amenity this proposal introduces. In summary, I strongly oppose the liquor store to be located at Longview Lake Hawea, and I respectfully ask the committee to decline this licence application.
Thank you very much. You're available to take any questions?
Yes, I am.
No, we have no questions, but thank you very much for your submissions.
Thank you for your time.
Cheerio. That concludes